court is the defendant, who is accompanied by her attorney, Ms. Mary Catherine Corrigan. We are here today for a change of plea hearing. It is the state's understanding that the defendant is prepared to withdraw her previously entered plea of not guilty and enter a plea of guilty to count 1, tampering with evidence, a felony of the 3rd degree, along with the attached firearm specification for 1 year. The state would move to dismiss the remaining count 2 at the time of sentencing. There is no agreement with regard to sentencing, and prison is mandatory in this case. Thank you.
Thank you. Ms. Corrigan, does that all sound accurate?
It does, Your Honor. Thank you.
And Ms. Verona, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here today?
Yes, I do, Your Honor.
And you can be seated at this time, both of you. I don't interpret that as any disrespect. It takes a little bit of time. It's easier to be sitting down when we go through everything here.
Thank you.
But you're able to hear what was said?
Yes, Your Honor.
They indicated to court they believe it's your intention to withdraw your previously entered plea of not guilty to count 1 specification. Count 2 would get dismissed. We would defer sentencing to get some reports completed, come back on a future date for sentencing. Where there's no agreement between the parties regarding any recommendations for sentencing, each side is free to recommend to the court whatever sentence they feel is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, and more importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything we're doing, all right?
Absolutely.
All right. Let's get started then. How old are you?
I am 48 years old, Your Honor.
Are you able to read and write the English language?
Yes, I am, Your Honor.
Any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes, I am.
Now, before coming into court here today, have you had any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No.
Not even prescribed medication?
Yes,
Nothing?
Your Honor. I am prescribed medication.
What prescribed medication would you have taken within the last couple of days?
I am on Lexapro. I am on hydroxyzine. I am on Prozocin. And then just stuff for my back. And that's it.
What is the stuff for your back?
The stuff for your back, is that,
I'm on
is that like a...
Roboxin. It's called Roboxin. And then I don't remember what it's called for my stomach for acid reflux.
Okay. So, in the paperwork I have, on the second page it reads, I'm not under the influence of any drugs or alcohol. I'm not taking any drugs or alcohol in a 48-hour period preceding this hearing. And I added, except for Lexapro, hydroxyzine, Prozocin, Roboxin, and acid reflux medication.
Yes, correct.
That sound accurate?
Yes, sure.
Now, any of those medications that I just listed that you've taken within the last couple days, do they in any way affect your ability to understand or appreciate where you are, what's going on around you, to communicate, anything?
If anything, they help me, Your Honor.
Okay. So no negative impact or influence because of these medications?
No, not at all.
Now, you would have been served with a copy of this indictment back in very end of October. That's the document, maybe beginning of November. The document that sets forth the charges you're accused of committing. Do you remember getting that?
Yes, I do.
And at some point you had the chance to look that over?
Yes, Your Honor.
Now, in that indictment, you are charged with 2 counts. You're pleading guilty to the first count, so I'm going to review that with you. If you have any questions, make sure you ask. But what's alleged here in count 1 and what you're admitting to is on or about September 15th, 2025 and or September 16th, 2025 in Willoughby Lake County, Ohio, that you, knowing that an official proceeding or investigation was in progress or was about to be or likely to be instituted, that you altered, destroyed, concealed, or removed any record, document, or thing with purpose to impair its value or availability as evidence in such proceeding or investigation. That conduct constitutes the offense of tampering with evidence. It's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in count 1?
I do, Your Honor.
Any questions about it?
No.
Now, there's also a firearm specification attached to this count that alleges that you had a firearm on or about your person or under your control while you committed the offense of tampering with evidence. Understand what's alleged in that specification?
I do.
Any questions about it?
No, Your Honor.
Now, there's a second count of this indictment of obstructing justice. It's a felony of third degree. That's being dismissed pursuant to the agreement. Is that your understanding?
It is, Your Honor.
Any questions about that charge?
I do not.
Well, then before I can accept your plea of guilty to count one that I just read to you, I need to make sure you understand all the rights you're giving up by pleading guilty. And you, first of all, have the right to have a trial. And a trial could be me as a judge, where I would listen to all the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by the jurors would have to be unanimous. Unanimous means all 12 of them would have to agree together, one way or the other, as each separate charge, whether you're guilty or not guilty. Do you understand that?
I do.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, you would have the right to have an attorney represent you at that trial. If you cannot afford an attorney, the court would appoint one for you free of charge to do that. Do you understand that?
I do.
Excuse me. Now, at a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty at a trial before you could ever be found guilty. You're presumed innocent of the charges, and the presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. Highest burden of proof we have in our justice system. And what it means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the charge beyond any reasonable doubt before you could ever be found guilty of this charge or specification at a trial. Do you understand that?
Mm-hmm. Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least in order to try to do that, prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. That's called cross-examination. She could ask him anything she wanted to within certain rules. Do you understand that?
Yes, Your
Do
Honor.
you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
I do.
Now, you'd also have the right at a trial. You can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request this court issue an order. We call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court to testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
I do.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes.
And since that's your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor is not allowed to call you as a witness and make you get up on the stand and force you to answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Okay.
Further understand that if we went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all for me regarding any of these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor, I do not.
Do you understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
I do.
Do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later you didn't do it or someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of the guilty plea is that you'll be found guilty by the court.
Yes.
And then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 3rd degree. This offense is punishable by a term in prison of a minimum of 9 months, a maximum of 36 months, or increments in between of either 12, 18, 24, or 30. So at the time of sentencing, so I'll select one of those numbers, 9, 12, 18, 24, 30, or 36, and that would be the number of months in prison you'd have to serve for the tampering with evidence charge. You understand that?
Yes, Your Honor.
Now, the charge also has what we call a firearm specification that's attached to it. This firearm specification requires the court impose a mandatory prison term of 1 year. That has to be served prior to and consecutive to whatever prison sentence I impose on the tampering with evidence, the 9, 12, 18, 24, 30, or 36 months.
Yes, Your Honor.
So you serve the 1 year first, and then you would serve whatever the prison term is on the tampering with evidence. So they have to be served consecutively, which means one after the other. You understand that?
Yes.
I do not have the ability, if you've heard the term concurrent before, concurrent means sentences are run together at the same time. I'm not allowed, I don't have the authority to run the firearm specification, the prison term for the tampering charge concurrent. They have to be consecutive. Do you understand
Okay.
that? Any questions about that?
No.
Okay. And in as much as the firearm specification requires a mandatory prison sentence, that means I'm required to impose a prison sentence on the tampering with evidence charge as well, the 9 to 36 month range I mentioned. You understand that?
I do.
Now, are you currently on probation or parole to any other courts or agencies?
I am not, Your Honor.
Do you have any other criminal charges pending against you anywhere?
I do not.
Your Honor, I don't think she does. She does have quite a checkered criminal history and does have some substance abuse issues, and she doesn't believe she does. We don't know of it. We don't.
Fair enough.
I just want to.
I'll explain the reason I'm asking. It's nothing more than if you have a pending charge against you, felony charge, and you're sentenced to prison on that other case before you're sentenced on this case, I could run. I'd have to run consecutive. This firearm specification has to be consecutive to anything else.
Okay.
But that's only if you're sentenced to prison before you come back here for sentencing.
Yeah.
Doubt that's happening because you're not going to get out here. It doesn't appear to that's the case to go anywhere else.
Yeah, Your Honor, I don't believe.
Okay, well, that's the only reason I'm telling you that.
Yeah,
If you're
thank
sentenced
you.
to prison before you're sentenced here, I could run my prison term consecutive to that. That's the
Okay.
only reason I'm asking that. I can't run it, concurrent or consecutive to some possible future unknown sentence. It's already got to be imposed.
Yeah, I honestly, Your Honor, as far as I know, I don't have anything.
Fine. That's the reason I was asking. The only
Yeah.
reason I was asking.
I've done everything in my possible ability when I fall down and if I fall down to get myself back into either a psych ward or any type of treatment. I never thought I'd be back in front of a judge again, Your Honor, so.
Were you? I may have asked you this, and if I did, I'll ask it again because I can't remember if I asked. Were you on probation or parole or post-release control to any other courts or agencies when this happened?
No.
Now, if a prison term is imposed in this case, upon your release from prison, you could be placed on what is called post-release control, sometimes referred to as parole. It's a period of supervision you would be on after you completed the prison sentence, and it could be, in this case, up to 2 years. You understand that?
Yes, Your Honor.
And if you're on post-release control and you were violating any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison or the mandatory prison sentence I just mentioned, there's other sanctions that could be ordered. You could be fined in this case up to $10,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any of that were applicable. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I was explaining the prison sentence, prison sentences, the possible prison sentences, and I told you it was mandatory, though, that prison had to be imposed. That means you are not eligible for probation, what's called community control sanctions. Do you understand that?
Yes, Your Honor.
Now, while you're not eligible for community control sanctions here at the time of sentencing, after you have served any mandatory prison term that would be imposed in this case it would be the 1 year for the firearm specification, you would be eligible at some point to request judicial release, which is a motion you could file with the court requesting to be released and put on community control sanctions. Now, you're not entitled to it, and it's not guaranteed you would get it, but you could request it after you serve some period of time after the mandatory prison sentence. You understand that?
Okay, thank you.
Lastly, when we come back here for sentencing, you'll have the right at that time to say anything you want me to know or consider.
Sure.
Your lawyer could speak on your behalf, recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor, thank you.
Do you understand that whatever the lawyers say at the time of sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think it was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty?
I do not, Your
You
Honor.
understand all the possible consequences?
I do.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to discuss this case with your lawyer and have her review the reports with you, discuss issues, answer whatever questions you may have?
I have.
Are you satisfied with the advice and counsel of your lawyer?
I am. Yes.
Has she or has anyone else made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering the plea freely and voluntarily?
Yes.
All right, any questions for me then at this time regarding anything we've talked about, the rights you're giving up, the penalties you face, what you're pleading guilty to? Any questions?
I do not, Your Honor.
You still want to plead guilty?
Yes, Your Honor.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the facts would show if we had a trial. I want you to listen to what she says because then I'm going to have some follow-up questions for you, all right?
Yes, Your Honor.
All right. Ms. Middleton?
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on September 15th, 2025, there was a shooting that took place at Fox Run Apartments in the city of Willoughby, Lake County, Ohio, where DeMonte Perry was shot and later died. The defendant was interviewed by the Willoughby Police Department where she admitted that she was aware of the shooting that occurred at Fox Run on September 15th, 2025, and that her son, Christopher Ferrona, had called her sometime after it happened. Christopher Ferrona told her that he was in trouble, and she told him that she was coming down there. Christopher Ferrona told the defendant that he had the gun. The defendant admitted to the Willoughby Police Department that she retrieved the gun from the bushes at Fox Run Apartments, again located in Willoughby, Lake County, Ohio, in order to assist Christopher Ferrona. She took the firearm and gave it to a drug dealer in Cleveland. The Willoughby Police Department was able to recover the firearm from that person and were able to confirm that the same firearm was used in the shooting on September 15th, 2025. Thank you.
Thank you. Ms. Ferrona, were you able to hear what the prosecutor had to say regarding what she believes the evidence would show if we had a trial?
Yes, I have.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
Okay, Your Honor, to a degree. When my son called me, I didn't go into where he was. We called Melvin Harris. I did go as close as I could. I did not go in. My son told me the gun
You did not go in where?
To the apartment.
to the apartment where it had happened. The next day, my child had my food card. This can all be proven.
I want to know if you tampered with this gun, which was evidence in a proceeding.
He wants to know, did you go and retrieve the gun
I
from
did,
the
Your Honor.
bushes?
Afterwards, yes.
Knowing that it was potentially evidence in a criminal
I did.
investigation?
Yes, Your Honor.
And you possessed it when you got it?
Yes, I did.
Anything else you'll be able to explain to the probation department. I just
Okay.
want to find out whether you are admitting to the specific elements of the offense that you...
Okay, I didn't know if you wanted to know exactly what had happened.
You're going to get a chance, you're going to go to the probation department and meet with them and give them your own version twice of what happened. You can talk to them orally and have an oral interview with them, and you're also going to get a chance to write it out if you want.
Okay.
So you'll get that opportunity. I'll get a chance to look at it. So I'm not review that.
Thank you.
Not an opportunity. I will review it. So, but the point here is just that you're admitting to the specific elements of the charge,
Okay.
which is what you just said, that you went, got that gun,
Yeah.
knowing that it was evidence in a criminal proceeding.
Yeah, I'm sorry, I was just a little confused.
That's all right.
Thank you.
Did you know that he had died at that point, though?
I did not.
Right,
It
well,
doesn't, I don't think it changes
No, it doesn't
the
change
actual
that.
elements of the facts.
Yeah,
but
Because it's just
Totally.
that it's a criminal investigation
Yes.
that you knew was going
Correct.
on. You knew that, correct?
Yes,
Yeah, okay.
yes.
Very well then, regarding count 1, charging you with tampering with evidence of felony of the 3rd degree, what is your plea to that?
Guilty.
Regarding the 1-year firearm specification, what is your plea to that?
Guilty.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand that document and that you sign it here in open court. Now, my understanding is before I came out here, you had a chance to go over that document with your lawyer. Is that correct?
Yes, Your Honor.
Ms. Corrigan, is that accurate? Did you review that with
I did,
Ms.
Judge.
Frona?
Yes.
Read it over with her?
Yes, sir.
Did she indicate an understanding of it to you when you did that?
She did, very much so.
Is that correct, Ms. Frona? So you understand the document?
Yes, Your Honor.
Any questions for me about what it says?
No, Your Honor.
It also appears you signed the document. Did you in fact sign it?
Yes.
You witnessed that, Ms. Corrigan?
I did.
And Ms. Simline, you as well?
Yes, Your Honor.
Very well, then at this time the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, made a knowing, intelligent, and voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Finding the defendant guilty of count 1, tampering with evidence, of felony of the 3rd degree in violation of 2921.12A1, along with the firearm specification. Count 2 will be dismissed. I'm going to defer sentencing, order a pre-sentence report and investigation, and I'll continue defendant's bond. Is there anything else for the record at this time, Ms. Himalayan?
Your Honor, can we get a victim impact statement as well?
Victim impact statement. Ms. Corrigan, anything else?
No, thank you, Judge.
Thank you.
All rise.
All right, I'll be in to see you. Depending on the weather, it might not be tomorrow, but
That's fine.
Okay.
And so here's the thing, remember what I said when you were here before, right? Talk to them, they all charge different amounts, have different payment plans, bring me the names of who you've talked to. I say the same thing to everybody, so I know I said it to you. And what did I say that could happen if you didn't do what I told you to do? Right, so you don't want to go to jail just because you don't do what I asked you to do, right? It's easy, just talk to 3 lawyers. Then if you can't afford them, there's options, but you have to follow the rules first. It's just that simple. If you can't follow the rules, you're going to end up in jail. Okay, so I'm going to reset your case 2 weeks. You have 2 weeks now to talk to 3 attorneys or get one hired. If you don't do that, then your bond will be raised for not following that court order. Yes, ma'am.
I'm going through a transition right now. I'm not able to work because I just got my kid the case with home.
Just do what I'm asking you to do, and then we'll talk about your options when you come back, okay? If you talk to them, you do what I say, you can't afford them, you can't come up with the money, then there's some options for you to maybe get a court-appointed attorney. But you're going to be required to follow those directions first, okay? All right, step in front of the clerk. Justin Payne. Good morning. Good, you're Justin Payne? Mr. Payne, were you able to get someone hired? Who'd you hire? Okay, did he, you've paid him and everything, or you're going to?
No, I had made it now, he said, I had to text him, I had to try or some hard comment or something, so he can be back this week.
Okay, so how much more do you need to pay him before, so have you hired him, I guess what I'm saying is sometimes they'll take a down payment for whatever is gonna get them on your case. You've already done all of that?
Yeah, I did a couple hundred.
Y'all didn't hear from him?
I'm working to make sure, Judge.
Yeah, I know.
Well, I think, I don't know if he's on our docket, but I know
He's in Hardin County.
he'll be around though. They're not starting back till, tomorrow too.
Okay.
But he hasn't filed anything.
But he's coming today? Do me a favor, just have a seat here in the courtroom until Mr. Kimler gets here. It sounds like he'll be here this morning. Don't leave until we tell you to, okay? Thank you.
Yeah, they're starting back tomorrow.
Okay. Brittany Davis. Mm-hmm. Good morning, you're Brittany Davis?
Yes, ma'am.
So, Ms. Davis, what happened with your drug patch?
I had a death in my family. I went to Dallas. My daughter got sick and they fell off in the hospital. I have documentation to show where I was when she was discharged.
What does any of that have to do with your drug patch coming
It
off?
fell off and I was in Dallas. I wasn't even involved at the time.
Have a seat in the jury box. We're gonna get you tested this morning. Richard Volry. Good morning, sir. You're Richard Volry? And Mr. Volry, this is your initial appearance in cause number 25 DCCR 1746. You're charged with aggravated assault with a deadly weapon from October 21st of 2025. And since you have made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm gonna do, sir, is reset your case for about 30 days or so. Give you some time to try to hire a lawyer. If you get a lawyer hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you'll step in front of the clerk, she'll give you a reset notice.
So while she pulls up the next contestant real quick, because the previous one had talked about her drug patch falling off, I just looked it up. According to Farm Check, which is a maker of those drug patches, the falling off is a rare occurrence, can be because of excessive sweat or soaking like in a hot tub can cause it. Improper application, but that tends to be found out very quickly. Or if it's being worn too long, over 14 days, just your cellular shedding can cause it to lose contact. But specifically, it's designed to be tamper evident, so if you try to remove it yourself, they'll know it. So just some FYIs there for you.
Mr. Ramirez, just have a seat for a few minutes and we'll check on all of that, okay? I do remember something about that. Probably because of...
Barbara, thank you for the $10. I very much appreciate that. I'm playing catch up. My brain is not on yet. I hope you had a great weekend. I did have a pretty good weekend overall, Barbara. We made a good dinner last night. Go back to the pre-show, check it out. I got a couple picks. But thank you so much again.
Good morning, you're Tashawn Bass. And Mr. Bass, this is your initial appearance in each of your cases. Cause number 25, DCCR 0832 and 0833. You're charged with aggravated sexual assault of a child from March 14th of 2023 and June 1st of 2024. Since you've made bond in your cases, have you had an opportunity to try to hire a lawyer? So what I'm gonna do, Mr. Bass, is reset your case about 30 days. Let's see, so this is one, you were certified as a juvenile, is that correct? Did you go through family court stuff first, juvenile? Okay. All right, so I'm gonna reset your case. How old are you now? 18. Are you working? Why not? Okay. Give me just a second. You're not still living at the same place with the complaining witness, right? Yeah. Okay, so what I'm gonna do this morning is appoint you an attorney, Mr. Bass. Okay, so you'll keep Mr. Rojas as your attorney. No, he's not here yet, but step in front of the clerk. She'll give you his information and when you need to contact him, okay? Brandell Griffin.
Hello.
Good morning. You're Brandell Griffin. And Mr. Griffin, did you talk to some attorneys or get someone hired?
I talked to 3 more. I couldn't get no one hired.
All right, who'd you talk to?
Judge Walker, my son Kyle, Sonia Hickory, and Crenshaw.
Okay, thank you for taking care of that, Mr. Griffin. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to make sure you fill it out accurately and completely because you're gonna swear under oath that it's all true and correct. If you'll step to the clerk on the end, she'll give you that paperwork.
Barbara, thank you for gifting 5 memberships. Very generous this morning. I surely appreciate that. I really do. By the way, that merch that you're looking for, I am still working on that. So hang tight. I'm getting closer. I just want it to be right.
You don't have anything on him, call or anything? No response, John? Let's see, I'm gonna, we haven't heard from him. I think what I'm gonna do, just based on the weather, is reset it 1 week instead of forfeiting the bond. So Kelvin Johnson will reset 1 week. Anthony McFarland, oh, hi. You're so sneaky.
I know, I ain't conspicuous. On Ramirez, Judge, that's not a case that's gonna be dismissed for doing the class. She did complete it. Our investigator spoke with her and really doesn't think that it's a case that should be dismissed.
Okay, sounds good. I'll take care of it. Thank you, Mr. Nichols. I'm going to do the same thing on that case and reset it 1 week. Mr. Ramirez, come back up, sir. So, Mr. Ramirez, the investigator has spoken with the complaining witness, and even though she's taken that class, they are not inclined to dismiss the case. So what that means is you're going to need to get you an attorney. So I'll reset your case for about 30 days to give you some time to get a lawyer hired. If you get someone hired before the next court date, bring the reset notice that you get to them. They'll tell you what to do. If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers and then bring me their names so I know you're trying and we'll discuss options. Okay? Step in front of the clerk.
So I've got my eyes on a bunch of different courtrooms across the country. It's kind of a mixed bag this morning. Some of it's probably weather related. A lot of people not showing up. Some courts that are usually running aren't quite going yet. I'm going to hang with Judge West here for just a little bit. It looks like they're queuing up some stuff in Judge Culotta's court, so barring something else, we'll probably go there in the next few minutes.
I know, Ms. Walker, 25 DCCR 1212.
Seen him
psychologist called him to make sure everything's okay.
Okay.
So if I could just have a couple of minutes,
Yeah,
I think we're gonna get,
okay.
get this worked out.
I'll hold, let me go ahead. Would you call his name, please? David Biano.
It's a lot of years of me standing here in front of the one of you.
I know.
That's why I got out of the jury box. I wasn't comfortable over.
I know.
I didn't want to be drug tested.
You never know what happens when you when you're sitting over there.
Ask me.
You know, yeah.
Testify.
I'll hold it while y'all check into that.
Thank you.
Sure. See, Mr. Morian, you have Carolyn Whitaker.
Yes, Your Honor.
2 cases. I saw him just walk in.
He was walking and walked back to the back. The weather here is not near as bad as it was in Jasper.
No, it's not, and you could have called because
Well, it could have been. No, the roads were great.
they were fine.
Oh, they were perfect. I drive a 1-ton anyway, so
You're gonna.
I'm all right. Gotta justify having that thing.
We could have had you pick up some others and bring them down on your way.
I try to keep it to where if I don't show up, something is
Something's bad.
Something is bad wrong. You know.
Did we lose him?
Yeah, I felt bad. I texted Tom Kelly this morning. I asked him, he said, "Oh no, Chris, I'm rolling."
Yeah, we got our county done. I'll hold it for just a minute. Let me hold it. Mr. Macon, you've got Bethany Loza Diaz. It's a sentencing. This is Mr. Hoffpower's sentencing. It's agreed. If somebody could.
I'll step in.
Thank you, Mr. Nichols. All right, ma'am, you are Bethany Loza Diaz? And Ms. Loza Diaz was previously in court, entered a plea of guilty to driving while intoxicated with a child passenger. I've received that pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Any additions or corrections? All right, Ms. Loza Diaz, I'm going to find that you previously entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of driving while intoxicated with a child passenger, sentence you in accordance with your agreement to a term of 2 years in the state jail prison, but probate that for 5 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over, and you'll be able to serve that 2-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, and then you could go to the state jail prison for up to for that 2 years you've already agreed to. Do you understand? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Macon. All right, ma'am, if you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you. Mr. Paget, you have Catherine Castillo sentencing. Castillo? Oh, yeah. Yeah.
Trinity Bell.
She went out to check on her. She's normally here on this. How are you this morning?
Good, how are you?
Oh, here you go. Okay, I was about to say, she's not one I worry about. Good morning.
So, good morning, you're Catherine Castillo? So before we go further, when I was reviewing the pre-sentence report, there's a new, or another, driving while intoxicated from July of 2025. Ms. Werner contacted your office, I think, and they contacted the lab. It was waiting on lab. They've pulled the case, and the evidence is going to get tested in the next batch, whatever that means. And so I guess I'm wondering what the plan is on that case. If we need to wait for sentencing on this, if
It may be better.
it obviously gives me some concern that she was on bond for one and
I'm not opposed to that.
got arrested for another.
And it also be another felony.
Yeah,
Obviously, so,
yeah. So do you have the auto ignition interlock device on your vehicle?
I do.
You don't? Are you driving?
No, my niece is driving.
Do you have a car? Do you ever drive?
No, I do.
Okay, you cannot, a condition of your bond already is, if you are not aware, you should be. But if you're not, then you cannot drive any vehicle that does not have that auto ignition interlock device on it. I feel like I think I want a scram device.
And that was a suggestion that Mr. Smith had noted on his PSI
Yeah.
as well, Judge.
I realize that both of those things are probably,
She does work full-time, but the only thing I would be concerned about is the finances, but
I mean, it's a requirement to have the auto ignition interlock by law, but I want proof that you have that on your car, this week. If you need to get it on your car, you need to send proof that you have it installed to Mr. Paget.
then I'll,
If I don't have proof of that by, let's say, Wednesday at 5 o'clock, then there will be an order, number one, that you don't drive, and number two, that you wear a scram device. So I want proof of that by Wednesday, okay? All right, we're gonna hold this because, we contacted, Ms. Werner contacted, your office, and they contacted the lab, and there's a new case, and they're gonna have it tested with the next batch.
DWI?
Yeah.
Yes,
I mean, it's in the PSI.
that's the first place I saw it.
Yeah.
The first I knew of it, actually.
Yeah, all right. Y'all, you're excused.
Thank you, Your Honor, I
Thank you.
appreciate it. Thank you, ladies, have a good day.
Thank you, Your Honor. If it please the court, we're before the court this morning in the matter of the State of Ohio versus Martin Martinez, case number 25 CR 1102. The defendant is present in the courtroom with his attorney, Mr. John Fatica. We're before the court this morning for purposes of sentencing, the defendant having pleaded guilty and been found guilty of one count theft, a felony of the 5th degree. Parties are ready to go forward, Your Honor.
Thank you, Mr. Fatika. Any reason not to go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of your client?
Your Honor, I'd like to start off by saying that Mr. Martinez understands he used very poor judgment not to show for his PSR. He did turn himself in voluntarily. 34 years old. He's currently employed as a laborer for Deck Rescue. He has 6 children. The youngest of his children, both under 2 years of age, live with him and his fiancee. He has 16 days of jail credit as of today.
How many?
16.
16. I thought you said 60.
No. We've submitted a number of letters that demonstrate that he has supportive family and friends. He's been active in AA. He's been a sponsor in the past. He relapsed here. And again, we understand that the court's options are limited, but we we'd ask for leniency. Thank you.
Mr. Martinez, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yeah, I wanted to apologize to the victims. I know they're not here. Mike and Anna were very kind to me in my life and provided me with an opportunity when I was in early recovery several years ago. I don't know where things went wrong, and I don't have an excuse for what I did for them. And I hope I can make restitution and a personal amends to them. I'd also like to apologize to my family sitting over there. They've stood by my side for 20 years of addiction. And even with the good years, I know there's always that anxiety of the next relapse. And I just love you and thank you for always being there for me. I'd like to address to you, I'm sorry I didn't show up. I wasn't in my right mind. And I just want to put this behind me. That's it.
Take anything else on behalf of the defense?
No, thank you, Your Honor.
Mr. DePiro for the state of Ohio.
Thank you, Your Honor. You know, Mr. and Mrs. Day are not here today, but I'll tell you, Mr. Day was here the last time we had a sentencing set in this matter. He sat in that hallway and he waited patiently to express to the court how the defendant's actions have hurt he himself and his wife and his business. The amount of restitution here is $6,006.07.
$6,006?
Yes. That's what we can show. That doesn't include the times that the defendant is seen on video reaching his hand into the shared tip jar and taking cash. That also doesn't additional conduct that the Days just simply didn't have time to scrutinize. The Days were very active and helpful in submitting documentation of the theft to the Mentor Police Department, Your Honor. And Mr. Day put together a spreadsheet that delineated every single time that the defendant stole from them. There's 188 entries in those months of time. And every single one, the Days looked at the video, documented it, wrote it down, so that we could prove that the defendant stole this money, which was not an easy task. And that took a lot of effort on their part. Over and above being victimized by the theft, they had to do all that. Mrs. Day confided in me that they had a prior incident with the defendant where he was stealing from them, but they gave them another chance because the Days know that the defendant has children to support and they did not want the defendant's children to suffer. And he just talked them into that he's a decent guy and that he should get another chance. Mrs. Day feels very strongly that that's not the case, that this is not a situation of a good guy with a drug problem. This is sustained criminal conduct that hurt them and is worthy of incarceration and punishment. The defendant does have credit for 16 days. Thank you.
Thank you. This court has considered the facts and circumstances of the offense involved and nature of the offense. I don't have a pre-sentence report to consider because the defendant failed to appear at the probation department for his interview and for the preparation of the pre-sentence report, so one was not able to be completed. I did receive a victim impact statement, and I've read and considered what the victims have had to say. I received multiple letters in support of the defendant from family members, acquaintances, and I've read all of those and taken those into consideration. I've considered what's been said here today by the defendant himself, his lawyer, the prosecutor. All this is considered by the court and by the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-29-12, the court finds in regards to factors that make the offense more or less serious. that the victims in this case not only suffered serious economic harm, but also emotional harm. They entrusted the defendant, and he violated that trust. The economic harm, as alluded to by the prosecutor, is not the only loss they had. They spent hours and hours putting stuff together and researching and investigating what happened here. The defendant's relationship with the victim facilitated the offense. The defendant had a position of trust with the victims in the business there and used that position of trust to commit this crime. No factors indicate that the offense is less serious than normal. This took place over a 7-month period of time. This wasn't just a one-time incident that occurred, which is what most offenses are. This was 7 months of planning and scheming. Every time money is taken, it's a crime itself. It's planned out and it's schemed, and the cover-up has to be involved. And he did this over and over and over, 180 some times, at minimum. And they trusted you. They helped you. They gave you advances on your pay every paycheck almost. Because you talked about how you were in financial need and dire straits, and you had kids to support. And they went out of their way to help you, and that's how you treated them. No factors, again, make this less serious. As for recidivism factors, the court notes that the defendant has a drug abuse problem. I don't know if it relates to the offense or not, but he hasn't done anything to address it. 20 years. I think one letter mentioned 18-year opioid addiction. He mentioned 20. He hasn't done anything to address it. He violated the conditions of his bond in using drugs while on bond and failing to appear for the probation department, failing to appear for his sentencing, even though he turned himself later in that day. He wasn't here for his sentencing. Factors indicating recidivism is less likely. The defendant doesn't have any criminal history. He's led a law-abiding life for a significant number of years. In terms of any convictions, he's been using drugs for 20 years. And obviously that's against the law, but he hasn't been convicted of any offenses with that. The problem here is that you didn't show up for your pre-sentence report. And you were specifically advised when we were here last time that in order to be considered for probation, a pre-sentence investigation had to be completed. And in order for a pre-sentence investigation to be completed, an interview with you had to take place. And you were specifically told if you fail to show up for that interview, probation cannot complete a report, and the court doesn't even have the lawful authority to put you on probation. And you were also told that if the court will not continue the sentencing to some later day to get the report done because it wasn't completed initially due to your lack of cooperation. And you even mentioned about how you had used shortly before that. And I specifically even told you, I watched the video before I came out here at the last hearing. I go, even if you're afraid of being arrested, you need to show up. It's important to show up no matter what. And you didn't show up. So I can't put you on probation. I don't have the authority to do it. And you were specifically told that. And you made that conscious decision not to do it, not to come in. And even in this case, you were supposed to show up on December 22nd. You didn't show up to probation. They contacted you, and they spoke to you. And they rescheduled it after the holiday. Because if you would have gone on the 22nd, you would have been arrested. Wouldn't have been able to spend the holiday with your kids. But they let you then give you another week. To December 29th. So if there was a warrant out for you, you could have been home with your kids for the holiday and still gotten your pre-sentence report done. Now, they didn't ask me about that beforehand. I don't know if I would have allowed it, but they allowed it. And you didn't show up on December 29th. So when you talk about wanting to spend holidays with family and kids, there may be something to that. But then December 29th rolls around after the holidays and you still don't show up. And December 30th and January 1st and January 3rd, you don't show up. That's a decision you made. Knowing the consequences, that's a decision you made. So there's nothing I can do about it. I'm not going to continue the sentencing to a later day to get a report done because you chose not to. You don't want a report. It's the only thing I can assume. I've been doing this for 22 years, and I've done that all the time when people don't show up. And there's no reason to have to create some exception in this particular case. So you violated the conditions of your bond. Prison's consistent with the purposes and principles of sentencing. And if you can't show up to the probation for a simple interview, I can't find you're amenable to probation. I mean, that's one of the basic conditions is you have to report to your probation officer, aside from whatever other conditions have to be followed. You can't use drugs. You use drugs. When you turned yourself in, you're positive for cocaine, marijuana, and fentanyl. So you're using this whole time you were out.
I have a drug problem.
So violate the conditions of his bond. Prison's consistent with the purposes and principles of sentencing. Again, the defendant is not amenable to any available community control sanctions. You know, the offense here, it's not just a possession, a drug charge. You stole from people over a 7-month period of time, thousands of dollars. There deserves to be consequences. Therefore, as a sentence to this court that in count 1, defendant serve a term in prison of 9 months. He has credit for 16 days he's already served. I need to advise you upon your release, you could be placed on post-release control for up to 2 years. If you are on post-release control and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 4.5 months, the maximum being 50% of the prison term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Defendant's ordered to pay all costs. Defendant's further ordered to pay restitution to the victims in the amount of $6,006.07 to be reduced by any amount that the victims may receive from insurance proceeds. So I know a claim was made. It hadn't been resolved by the time of the victim impact statement. At a minimum, it'll be a $1,000 deductible, but I'm putting the full amount now, again, to be reduced by whatever amount is received from insurance proceeds. I think that covers everything. Mr. Tapiro, anything else for the record?
No, Your Honor. Thank you.
Mr. Fatika?
No, thank you, Your Honor.
All rise.
Michigan, Judge Middleton.
Mr. Fletcher is in custody, has been in custody for 38 days, according to my calculation. Prosecuting Attorney Deborah Davis is present, as well as Assistant Abby Stoll. Let's start with the Fletcher case. It is set for 10:30. Mr. Fletcher was charged with aggravated assault for an incident that occurred at Yoder's on December 19th. He's been in custody, I think, since that time. Defendant is also on probation in Cass County, and I believe was headed to the probation center. Mr. George, this is a case I think we needed some help from Pivotal or other mental health services. If I didn't call the case, it's 252602, People versus Travis Fletcher. Mr. George, what's the status here?
Thank you, Your Honor. I've had the opportunity to see some correspondence from Ms. Frank, who's our individual at Pivotal at the jail, as well as some conversations with my client. I think what's clear here is there is significant diagnosed mental health concerns with my client. Since he has been in custody, it's my understanding that he has been medicated. That was one that was consistent here. He did come in at the first pretrial and enter a plea of guilty to the charge of offense. It's my view from talking to him, Your Honor, that this was a cry for help for him. Doesn't justify what he did, but I think it gives the court some reason why he did what he did. But anytime that anybody in the community is affected in this way, Mr. Fletcher understands that it's not acceptable. Going forward, I think there's going to have to be a significant mental health treatment component for Mr. Fletcher. He indicates that he wants to be committed to some type of facility, so he has the ability to access those resources. I think he does have concerns that when he's not in custody, whether he can access his medications that he needs. But I also at the same time understand that he is currently on MDOC probation out of Cass County. So I don't know if this court is, looking to try to put him on any type of supervision here where significant supervision over in Cass County. All in all, Your Honor, obviously this is it's not a good situation. The facts are terrible. But I would just ask the court to consider some of the mental health concerns that my client has, and we're making a determination on what's most appropriate. Thank you.
I believe I did make a referral to Ms. Frank at the jail after this plea. And I'm pleased to hear that she's doing a great job. I can't say enough good things about her. She follows up every time I ask her for help. But what's his status with Cass County? Is he still envisioned to be going to the probation center, or do we know what their plan for him is?
Your Honor, I asked him what his understanding of what Cass is going to do, and I don't know that that's clear. Based on some information, and Ms. Davis, if she has more accurate information, can correct me. But I think that there was some type of issue about there was supposed to be a hold or something that was put on the place and not released. And I'm assuming at this point that hold has been corrected. So I would imagine when this sentence is over, Cass is going to deal with it. I don't know specifically what they're going to do, but I think he's going to have to address that Cass County situation.
Yeah, as I understand it, he was improperly released from the jail, went from the jail to Yoder's where this happened. I'm not sure what the status of all that is, but Ms. Davis, you got any more enlightenment for us on this?
Maybe a little bit, Your Honor. Unfortunately, I don't have a copy of his PSI from Cass County to kind of reference like what his guidelines were and what their plan.
What was the charge?
So the charges were possession of methamphetamine and malicious destruction of fire and police property and R&O, I believe. Yes. So he was sentenced to confinement for 365 days. And then a concurrent probation of 36 months. So his sentencing was in August of 25. The arrest by the Dowagiac Police Department was in February of 2025. So it appears that, from my understanding of all of these different agencies and people involved, that he completed his jail term at Cass, but was then being placed at the Twin County Probation Center. But when he got to the probation center, he said that he didn't think that this was part of the deal. He didn't want to be here, didn't want to do this. And there was some sort of commotion caused, which then caused the jail to the police to come and take him to the jail. And they notified Cass County. It's my understanding that Cass County planned to come over and get him and take him back to Cass County. But there was some sort of confusion with paperwork being faxed over ahead of time, and they released him before Cass County got there to pick him up, which is what led to, yes, him walking through the village of Centerville, looking for a ride in the Dollar General and not getting one, and going into Yoder's and doing what he did. I understand that mental health obviously is an issue. However, you know, these are things that he lied to the officer and said he tripped. And then we have very good video showing that he did not, in fact, trip. This family, the mother and the 2 children, are extremely traumatized over this. Thankfully, there was a lot of people around. Standard by, like, went and chased him, and they had a good description of him, and he was able to be picked up. But that doesn't cure the issues here. I'm hopeful that Cass County has a straddle cell prison time waiting for him, because he's not safe to be out in the community, obviously. Whether mental health issues or drug issues or a combination thereof, we have serious concerns, and we would ask for the full year in jail for this. The victim would like to speak. She obviously is shaken up over all of this. Other than that, we would ask the court.
You want to hold him in our jail for a year before Cass County does their potential prison commitment?
I don't necessarily want to hold him here for the year, but if he's sentenced, then I can guarantee that he's going to be either here or MDOC. I don't know what Cass County might do on the PV, but I mean,
Well,
he's
the problem is
exhausted.
nobody asked. I was hoping maybe somebody would have talked to Cass County and said, what's the plan here? But we don't know that. But certainly this is a scary circumstance.
And I've been in contact with Cass County since the day this happened. So they are aware of what happened. They were aware of what the bond was set at, and my concerns that if he were to somehow post bond, to make sure that they had their hold in place. So I've not heard back.
So do we believe the Cass County hold is in place?
I'm not sure. They haven't returned my calls.
You're nodding your head. Do you have some knowledge about this?
Say again, Your Honor?
Hello, Deputy Studebaker. Judge Middleton calling from the bench. Does Cass County have a hold on Travis Devon Fletcher? What was the date of that? All right, what was the date of the most recent detainer? All right, thank you. Bye. He was supposed to have the detainer as of December 18th, but apparently something happened and he got rearrested. And according to Deputy Studebaker, Cass County placed a detainer on him, a probation detainer on December 19th. So there is currently a detainer for Cass County. So if he were to post bond, he would go to Cass County.
And Your Honor, part of the request for a significant amount of jail time is based on the unknown for Cass County. If he's used up all of his local time, so Cass County probation violation, if they go forward with it, It's either nothing and you continue on probation, or you go to DOC. Those are the two options, it appears. And my concern is that if they choose to not send him to DOC and he's just released on probation, that would be a disservice to our community. So also there is restitution that is being requested. However, it's a significant amount of medical bills and the victim does not have everything in order.
All I saw was the $50
That was her vest.
vest.
Yes.
Is
So-
there more?
Yes, she had to go to the hospital. She had CT scan. Her knee is injured from it. So there's a significant amount of medical that will be coming, obviously. Those aren't,
But we don't have that yet.
no, she's working on getting the information from the hospital. She went to Three Rivers Health for those tests.
Have they submitted a crime victims' rights claim on her behalf?
I don't know.
Somebody's
Yeah, I was gonna
busting
say,
out of the
somebody's
flooded
busting
back
out
room.
the back room.
They're probably working on it.
I don't know if they have or not. We can certainly explore that. And obviously, with the defendant's situation, getting restitution from him, it's going to be very difficult. But we would just ask that restitution be reserved
Okay.
on that.
And your complainant wishes to speak. Ms.
Yes.
Morrissey, would you come forward?
I have her sit at my.
Yeah, that'd be fine. Good morning. Would you state your name for the record, please?
Morrissey,
Could you spell your last name?
Morrissey.
All right. What would you like me to know?
It was Thursday afternoon, about 4:30 p.m. And my two girls and I were heading to Sturgis for my oldest tumbling practice. They talked me into stopping for donuts at Yoder's, which we've done a few times before. It's a few days before Christmas, so we say hello and Merry Christmas to the Salvation Army bell ringer outside. Upon entering the store, we see their 12 Days of Christmas giveaway, and I fill out a piece of paper to enter. The girls notice that they have an elf hidden somewhere in the store, so as we make our way over to the bakery side for donuts, they are looking for the hidden elf. My girls decide on a donut to share, and I grab a box to fill. I set the box down briefly and put on the provided plastic food gloves and get ready to open the first case to get their donut. As I'm putting on the glove, I'm shoved into the glass donut case and see glass shatter in front of my face. In the time it takes to be body slammed into the case and for me to turn around, I see a man running for the door and yelling as he exits. I stand there in disbelief for a moment and see my bleeding hands cut from the glass. I quickly ask my girls if they're okay. They are silent, but manage to tell me they are physically okay. A male customer approaches me and asks if I know that guy, and I say no, I've never seen him before in my life. This kind man then takes off running after the man who just shoved me. Another customer, a female, and two employees tend to my care. One asked, "Do you want me to call 911?" And my response was, "Yes, please." The customer and other employee took me and my girls into a bathroom around the corner to help clean me up as we waited for the police and the EMTs. I'm in utter shock, confusion, and just running on adrenaline. I must have asked my girls if they were sure they weren't hit about 50 times. My oldest, only 8, I'm so incredibly proud of her. We've practiced making emergency emergency calls before, but thankfully never had to utilize it until this day. I instructed her to call Daddy and my mom. She was so calm and relayed the necessary information to both. I fully believe her staying calm helped her younger sister, only 6, to also stay calm. This in turn helped me. I get my hands all cleaned and bandaged up and head back out to the main bakery area to wait for someone, anyone, to arrive. At this point, I've noticed that the vest I was wearing was ripped in a couple places from the impact, and my knees are really starting to bother me. My mom arrives first, and I have a brief moment of relief and cry as I hug her as she takes my babies away from the area. Then the police arrived and told me that the man had already been detained thanks to the description given by the employee through dispatch and the customer who went after him. He claims he tripped, and I guess that's what he yelled as he ran away. The employee was phenomenal in making sure I'm okay and providing her witness statement and guiding officers to view the surveillance. EMTs arrived and brought me outside to check me out. It's starting to rain outside, and I'm still running on adrenaline. Prior to them arriving, I had my daughter take photos of my face and shoulder, which are both red from impact. The police climb aboard the ambulance and do the same, as well as photograph my hands and knees. I'm shaking as I sit in the ambulance when my husband finally arrives, having to leave in the middle of work. We decided to go to the hospital ourselves and not take up an ambulance for someone who might really need it, as I'm able to walk, though with a lot of pain. I say goodbye to my mom and babies, and off to the hospital I go. I had to sit for a couple hours in the waiting room before being taken back to a room. As I sat, my head began pounding, and I had to ask for some pain medication. My knees are throbbing as I sit in a wheelchair, and I asked for an ice pack. I received both, and to just touch the ice gently to my knee was excruciating. Once back in a room, I've now had to explain my situation for the 5th time. My husband and I are sitting in our room, and I'm just trying to deep breathe through the pain and the thoughts of what just unfolded hours ago. I'm sent back for a head CT due to the impact of my face, and x-rays for both of my knees clear, and I just need all these cuts and bruises to heal. Once I finally make it home to my babies, now 11:30 p.m., and send my mom home, the toll on my children begins. The whole time I'm at the hospital, my mom is with them, and I keep asking if I'm okay. I chat with them briefly on the phone to help calm their nerves, while also helping calm mine. But what's home is where it really begins. The nightmares, causing both my children to have to sleep with me at night. Me holding them tight as they tell me it was very scary. The emotional toll really doesn't hit me until the next morning. Being pregnant twice before, never have I ever experienced so many emotions or the amount of crying. My youngest looks like she's seen a ghost and starts acting out. Her being fixated on something so much she's in full tantrum and hysterics if she doesn't get her way. When I finally get her calmed down and figured out it has nothing to do with what she's fixated on, she tells me I don't want it to happen again. I'd gone to the salon where my mom works to get a pedicure because I needed something normal and just for me. Knowing my mom was there was comforting. I didn't feel like I could be alone, and I still don't. My husband takes the children to the store after dropping me off to get the groceries we were unable to get the night before. Once home, my youngest tells me she saw a man that looked like him, and I don't want it to happen again. Knowing what she meant by this, she must have seen an African-American man, as that's who assaulted me. Being a Christian woman and a homeschooling mom, I've taught my children that God says there's only one race, the human race. I had to be mom and talk about how we know there are bad people in the world, and some of those bad people want to hurt us. That's why we stay close to mommy when out. But there are also more good people within the world, like those that helped us that night. And while I can't say it'll never happen, we have to always choose to see the good in people because that's what God wants. The nightmares continue for my children and myself. Being so close to Christmas, I'm not now looking forward to it, but I have to for my children. While I'm currently scared to be alone, loud noises scared me. Someone coming up from behind me just to check on me makes me jump. I can't let this man control my life. I'm a mom, and for that reason, I feel like I'm carrying 3 times the weight of emotions and trauma as my kids were involved. Christmas with family afterwards is something I wasn't prepared for. I feel as if he took my independence and sense of security away. I've sought guidance from a counselor to help me process the events and to help my children heal. The 2 things she suggested I do with my girls are 1, ask them what was the worst thing that happened, and 2, picture a pie. It has 8 slices. We'll call this the responsibility pie. How many pieces of pie does each person or persons get? Who is to blame or responsible for what happened? Mom, you, sister, or the man? Both of my children answered the same for both when sitting down separately with myself and my husband. The glass breaking was the worst part because it hurt mommy, and the man gets all 8 pieces of the pie. And my youngest clearly saw more than what she claims, as she gave me a complete description of what the man was wearing. My oldest remembers a black blur because it was so fast. Images they will never be able to get out of their heads at just 8 and 6 years old. While my face is finally healed, the knot on my bruised shoulder still remains, which after returning to the doctor for a checkup, shows the knot is actually a hematoma that's formed. My thigh and left knee bruising are fading, and while my right knee remains the worst from the impact, my hands still bear cuts, and I'm reminded every day of the horrific trauma we experienced while just minding our business. The bruises and cuts will heal, but the scar that's been left in my heart is permanent. I'm a strong woman and will overcome this. I have to for my girls. I won't let him get away with stealing my independence or security. I'm labeled now as a victim, but I choose to be a survivor. I've told my girls that jail is grown-up timeout for when grown-ups do something wrong and need to be punished. We're resting easier at night knowing he is where he should be and not harming anyone else. My youngest says, I hope he's in timeout for a long time, and if it's his birthday, that they don't give him any birthday cake or ice cream as punishment. I can't imagine letting someone out into our world who would go around and assault another human being, let alone a mother and her children, for no apparent reason. I feel safer knowing he's locked up and hopefully remains there for a long time. As I sit here now, a month after the incident, I'm just now starting to feel comfortable with going out by myself or with my children again. I was finally able to allow a friend to give me a quick hug, something I have been guarded against. The idea of physical contact or being surrounded by others makes me nervous, even if those people are friends or family. My injuries are fading, though my right knee now requires physical therapy. I'm hoping that today allows me to feel as though I can breathe again and a weight has been lifted. Only time will tell. I'm a Christian woman, so therefore I don't wish ill will on anyone. However, I also believe in justice to the full extent of the law and pray that this man receives no leniency on the punishment for his crime and that he gets help as a result of his actions. Whatever his claim for his reasoning is no excuse for the torment and random act of violence he carried out. Thank you.
Thank you. Mr. Fletcher, you got to hear live and in person what this incident affected on this woman and her family. I did make a referral on the day of your plea, January 2nd, to our local Pivotal. Have you been in contact with Lauren and working with the people at Pivotal here in St. Joseph County?
I've talked to her, but we didn't really talk.
All right, apparently didn't see much. In my notes, I said we need police report, victim input, and input from the Cass County Department of Corrections. We got the first 2, but we don't know what Cass County has in mind. Mr. Fletcher, this is your opportunity to say anything you want me to know, anything you want to say.
I apologize. I know apologies, sometimes aren't accepted. I just want to let you know that I'm still sorry.
Well, that's a start.
I don't know exactly what happened there because of my mental health issues.
At the first opportunity with a lawyer, you did accept responsibility for it. The charge is aggravated assault. Assault comes in different varieties, from assault and battery up to first-degree murder. Aggravated assault is a misdemeanor. It's punishable by up to a year in jail and a fine of up to $1,000. That charge closely fits these facts. It's an injury that requires medical treatment, but it did not involve a weapon and did not involve intent to commit great bodily harm. So the charge fits what I understand the facts to be. And there's a dilemma here. I think I canceled the defendant's bond at the time of his plea. He's been in jail now for 38 days. He's on probation on a felony charge in Cass County. They gave him 365 days in the county jail, which is the most you can do on a felony charge. Anything over 365 days requires a prison sentence. They also then put him on probation. And apparently he was gonna go finish out his probation for a term at the Twin County Community Probation Center in Three Rivers. The twin counties are Cass and St. Joe County. Started that program jointly almost 50 years ago. We now take inmates and defendants from a number of counties, but it's a Cass St. Joseph County thing. I don't know what happened. The ball got dropped. The defendant got released from the jail, which never should have happened. And now we're seeing the consequence to this lady and her family. It's a strange kind of offense. There's a mental health component to it, to be sure. I don't think no insanity or diminished capacity defense has been raised. The defendant simply accepted responsibility. So all that Cass County has left is either, as Ms. Davis says, to kick him off probation or to institute a prison sentence. Hopefully, if someone commits a aggravated assault while they're on a felony probation, that should be basis for a probation violation. But nobody ever asked. My fear is if I grant 365 days, they may just call it good and discharge him from probation. At that point, there'd be no additional supervision. But we don't know. If I gave him time served, they would be compelled to do something. I would rather he was on some sort of continued supervision in Cass County, but we don't know the answer to that. My fear, as I said, if I simply grant 365 days in jail, he'll do 300 days minus 38, and then he'll be out without any supervision. And there's no sense for me to put him on probation because I would have used up every available day of jail. So I'm gonna try this. I'm gonna do 100 days jail, credit 38, leaving 62 days to serve, may be released to Cass County Department of Corrections. I'll put to Cass County on detainer. Fine is $0. I referred him for mental health services, and apparently he didn't avail himself of it much. $125 in costs, which are required, or 2 additional days, and I'll reserve as Ms. Davis requested on restitution. Mr. Fletcher, have you heard anything from your probation agent since you've been arrested? This gives them 62 days to do something. As I said, even in the world we're in, I hope an offense like this would warrant a probation violation. Now, what you point out is the randomness of the world we live in. You live in a community that we like and we consider it to be safe. Yoder's might be our favorite place anywhere. If you think of a safe place, that would be it. You're in there on a Thursday with your kids, nothing unusual. Mistakes were made and a lightning bolt strikes and you get shoved through a plate glass cabinet. I've been there. I know exactly where this took place. I guess we're all subject to the vagaries of randomness. You didn't deserve this. And I hope you can get some healing from this. He wasn't mad at you. This was not focused on you. You were in the wrong place at the wrong time. And the only way we can avoid that is to never go anywhere or never do anything. You're going to continue to live your life and do things with your kids and have a family. You can't never go anywhere or never do anything. Mr. Fletcher, you need some significant mental health intervention. I tried to start some and you weren't interested. The probation center, if they hadn't accidentally let you out of jail, might have been a good start for some of that. At any rate, that's my sentence. 100 days, credit 38, leaving 62 days, $125 in fines and costs, or 2 additional days. And you may be released to Cass County on their detainer if they so elect. All right, sir, you can go with the court officer.
Thank you.
Thank you.
I did get a text during the hearing from Victor Fitz, and he's checking on what Cass is going to do.
Okay.
We'll follow up. So, thank you.
All right, thank you.
Bye.
Kevin Lyle Beebe.
Told me to tell you I paid my ticket.
Good.
When I owed $200, I didn't.
Well, good. That's the good news.
I
The
didn't
bad
even know
news-
I had warrants. My brother's,
You
my
got
brother's
2
wife
warrants,
was
so-
actually Beebe. She works for 911. She told me about it. I was like, what? So I
You
came
got
and took
2
care of it.
open warrants, so let's talk about all this. You're here today for an arraignment on a charge of disorderly person from September 11th. That's file 251903. You didn't show up for arraignment.
Yeah, that one I moved to Florida. Then I came back and went to rehab for my alcohol. And then I forgot all about it.
Let's look at the first one.
Not to interrupt, but I'm going to interrupt. Lindsay, thank you for gifting 10 memberships. Lindsay had my back yesterday, and I called that out in the pre-show today. And all of you, I just want you to know that y'all mean a lot to me. You tune in every day, you watch, you've got my back, you're very supportive, and I just appreciate all of you. So Lindsay and the rest of you, thank you so much.
Beginning of December.
What's your new job?
I'm working at Summit Polymers. I'm actually making car parts for police cars, the dashboards, the Ford Explorers, the 2026 ones.
Well, this one was, holy smoly, the one
We
in
make all types of different
September
ones, too.
11th,
Most
public
Ford Explorers.
intoxication somewhere, you were a .368 Did they
Yeah,
take-
I went to rehab though. I went to a light.
Did they
recovery
take you to the
center.
hospital?
I
They're
don't,
supposed to take you to the hospital if you're above 3.2.
I don't remember. I don't think so. I don't really remember.
At
I don't
point
know, it was a long
383,
time
if they put a wick in your mouth and lit it, it would burn.
ago. Yeah, I know. That's why I moved to Florida for a little while. Then I came back and I went to rehab. And then my brother's wife works for 911, Ashley Beebe. She told me, "Oh, you got warrants." I was like, "What?" So I looked them up, man. And I called you guys to get a court date and get this stuff taken care of.
All right.
I don't know
Where did you go in Florida?
Miami.
Warmer there than here, but it's a lot more expensive.
Yeah, I know. That's why I came back because I couldn't afford it down there.
All right, you have an open warrant for another disorderly person in file 251299. That's from July 1st of 2025. That actually precedes the September case. And the other warrant is on the same date. No, 2 days later, September 13th. 252536 OM. 251299. Miami's full of rich people and poor people.
I know. Yeah, I know. It's mostly all poor people, but unless you go downtown. But I couldn't afford it down there, so I had to
All right, I'm
come
gonna
here.
arraign you on all cases.
I have no clue where the retail fraud came from because I
Well,
was
let's take a look at it.
never arrested for it.
That was the 13th. Sometimes they'll review a video or something. Let's see what the retail fraud is about.
I don't think I'm stealing anything.
3-6. It allegedly occurred at Walmart on September 13th.
I don't know.
Oh, yeah. They followed you. You came out of the bathroom. This is all on video. You took allegedly some boots, 68.98, a Lunchable grilled cheese, 3.98, some Klondike Reese's 6-pack, 73.18. They have a video of you walking in the store and walking out of the store with you wearing the stolen boots.
I must have been drunk.
Well,
That's why I
maybe
quit
so.
drinking.
All right.
I just don't want to lose my job. I kind of want to get all this stuff taken care of too. I paid you $200.
Well, I'm gonna
for it.
recall the warrants.
Thanks.
I'm gonna appoint an attorney. Let's see what else we got here. You don't seem to have any, oh yeah, you do. You paid that $200 fine today?
Yes, sir.
All right, very good.
I got about $50 left in my pocket.
All right, you presented yourself at the court on these warrants. You paid an outstanding fine. So it shows good faith on your part. You're back in the community. I'm gonna appoint an attorney, set attorney pretrial for 3/6/26 at 8:30. I have lost Mr. George. For those other pretrials. All right, you go out to the counter. We'll get a lawyer. What shift are you working at Summit?
Second shift.
All right, well, you won't have to miss
4
work.
to 12:30.
That's expensive living at the motel.
Last night because it went in my head. There we go.
All right, the ladies at the counter are gonna give you your attorney's name and number. I want you to call that lawyer, make an appointment to discuss this matter with them prior to March 6th, and I'll see you at 8:30 that morning.
All right, sir. Thank you very much.
All right, let's talk about
Great Granny, thank you for the $5. You say I like TCF because you can listen in peace. Well, thank you. We try to do that around here. Just have a place where people can gather and it's welcoming and enjoyable. And but we're still watching some serious stuff. But I'm glad you enjoy it, and thanks so much for being part of the community, and thank you again for the super chat. All right, good morning once again, everybody. TCF Live on a Tuesday. It's good to have you all here. Let's change it up. We've got some other courts starting to come online now, but let's stay in Michigan, go over and say good morning to Judge Dad.
So what happened here?
So Ms. Vander Dog, I don't want to mispronounce it, I apologize, came into the dealership to purchase a vehicle. And when she purchased that vehicle, she was supposed to bring back a cashier's check for the amount that she owed, and she never did.
Did you sign the title over?
We did, we stated it for,
Wait a minute, you signed the title over to her?
Yes, we
Did
did.
she register it with the Secretary of State?
Yeah.
Why would you do that before you got the money? Or was this a later payment, balloon payment at the end?
It was, if you look on the attachment, sir, you'll see the payment plan that she organized with the dealership.
Jeez, I see. Okay, good enough. So she owes you guys, she got the car, she didn't pay for it. You still are owed $6,216. And 60 cents. You should have some court costs too. Can you give me a breakdown of those? I need to know what you paid for.
For Dino, it was $75.
Okay,
To file our court fees was $70, sir. I have those receipts with me.
so 75 and 70, right?
Yes, that's correct.
So that's $145, and on top of the 6216 60. So that should be another 145. That should be 63, 61, 60, right?
That's correct.
All right, judgment is entered. I'm going to give you a copy of, I'm going to ask you to go down the hall. Just give him a couple minutes. He'll bring the file down. I filled out the judgment for you and you're all set. I hope you can collect that. Best of luck.
Thank you, sir.
Is Flat Rock out there? People again, Sterling, Joseph Wright, 25W84088-1A and B, and also 25F244059. Good morning, Mr. Wright. Your name? Muted. I can't hear him.
Good
Your
morning, Judge Sterling Wright.
All right, officer, your name?
Officer Porter.
Yeah, I'm going to ask you to take your hat off if you would, Mr. Westmoreland, your name?
Good morning, Your Honor. Attorney Corey Westmoreland, appearing on behalf of Mr. Wright.
We have a charge here of disorderly person, public intox, and minor in possession from November 22nd. He was in front of me on December 11th. The case that he was in here on November 22, he didn't show up for on December 17th. And he also has an open intox. Where's he been?
Your Honor, he's currently living down on the road and he didn't have,
All right. I see. Where was he picked up at, officer?
in Flat Rock. That I'm not sure. I believe his address is in Flat Rock. So,
Right. You didn't graduate, did you, son?
No, I did not graduate from high school. No.
I can't hear you.
No, I did not graduate.
You're not in high school anymore.
No, I'm not in high school anymore.
Are you working?
Yes.
Where?
In Flat Rock. I move furniture.
For who?
Work for a moving company.
Which one?
Wheel Deal Moving.
Will Deal Moving?
Wheel, like WILL. Wheel. Real deal moving.
Yeah.
I also work for other companies as well, though.
You know why I knew you didn't graduate?
How'd you know that?
Because when you act this irresponsible, there's no way you get through high school. No way. How many hours do you work per week?
Maybe around 40.
Maybe around 40. How much do you make per hour?
$20.
You make $800 a week. That's pretty good. Is that how much you make per week?
Somewhere around there.
Why isn't he showing up besides the fact that he didn't have a ride, even though his parents live in Flat Rock and he works out of Flat Rock? That's just an excuse, isn't it, Mr. Bright?
Absolutely not.
Oh, it's not an excuse? Well, then we're going to make sure you got a ride to court. How's that? I'll make sure you have a ride to court. And they can take you over from the Flat Rock Police Department when I get ready to handle this, okay? And then you're going to have to post a high bond. So, you know, don't tell your lawyer things that are not true. Okay?
Yeah, I think he acknowledges, and he meant to say was, it's not a good excuse, but he understands. After I spoke with him, he does understand the importance of the hearing and making sure he clears all his matters.
So he's got a November 22 minor in possession. He must have a prior minor in possession, right? Yeah, that's what that says on the ticket. That's why they charged it as a misdemeanor. So you have that case. Give me 1 second, if you would, please. You've been in front of me before. I remember you. You know what? You have been, right?
Think so.
In fact, you were in front of me at the Flat Rock Police Department, sitting there just as you are now, right?
No, I don't think that was it. I think I had came in to come see you.
You'd come to Flat Rock, or you came to the court?
No, I came to the courtroom to see you. I was in court when I see you.
You gonna grow up, or you gonna act like this your whole life?
No, I'm really ready to figure this out and make it to where I don't got these warrants and I don't have all these fines, and we can just put it on one accord to where I can just boom, boom, boom and knock everything down, and just instead of having warrants here and being, and keep going through this process.
Yeah, yeah, well, you're bringing this on yourself.
Well, I wasn't sure about a warrant. Like, I didn't know how that worked really. I wasn't knowing, you feel me?
Do you stand mute and wait for a reading on the failure to pay, which is 25R514323?
That's correct.
It's a mute on there.
You missed too many times here, son. John, you're gonna have to go over there. We're gonna have to do a screening as I ordered quite some time ago. So here's what I'm doing. Anything else, Mr. Westmoreland?
Not at this time, Judge.
Well, I'll give you an early court date. I'll do that because I want to be a lot more fair with you than you have been with us. Okay?
Okay.
Is that all right with you, or?
Yes, yeah.
Keep doing this. I don't get it. You've missed court 4 or 5 times here. 1,510% on 25F244059. We're going to need a screening and assessment and probation, John, to get on to do screening on 25F244059. You have 210. I'm entering a not guilty plea on 25R514323. That'll be $100 cash. I will set that for January the 29th, and that will be at 9:15. And then on Judge Hessen's cases, you have an open intox and you have a minor in possession. 10% on that. No contact with prosecution witnesses, no alcohol, no marijuana, no illegal drugs. Do you understand all that? And that's on both the open intox and the MIP. Do you understand that?
Yes, Your Honor.
So that'll be on January 29th at 9:45, the pretrial on that. So you got a contempt hearing in front of me, a sentencing in front of me, and then you've got pretrials in front of Judge Heston on the 29th, and again, that will be at 9:45. Okay? You cannot leave the state. You cannot violate a law. You must appear in court as directed. You need to get to court on time, sir. Okay? Don't be late. We understand one another?
Yes.
Thanks.
Probation need to zoom in.
And we're gonna give you, yes, probation needs to zoom in with him, officer, so if you'll just bear with us. And we'll get you, tell him, John, tell whoever down there, I want him to have a court-appointed lawyer.
All right, so let's go on the record in the matter of the Andrela Hager, 22991. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Schenke here on behalf of Ms. Hager. I'm in the wrong thing.
No, sir, you're right where you're supposed to be. It's just gonna be a little bit before your hearing. Okay, and so ma'am, your name for the record, please.
Andrela Hager.
Okay, thank you. Today is the date scheduled for a probation violation. Ms. Hager is on probation for attempt retail fraud. And it's alleged that she failed to appear for probation visits on November 9th of 2022 and November 29th of 2022. And counsel?
Yes, Your Honor, I had a review of the documentation that was sent to me. It indicates that, yes, she missed these 2 dates. I gave her the notion of what she was able to do regarding the hearing to contest whether or not she was there on those date and time. That will not be necessary. She'll admit that she failed to appear at those probation visits, Your Honor.
Okay, and so ma'am, please raise your right hand. You solemnly swear or affirm testimony about to give in this matter to be the truth, the whole truth, and nothing but the truth. Okay, I need you to speak up a little bit more loudly, please.
Yeah.
Perfect, thank you. I'm recording on my device here, so that's okay. And so ma'am, you did hear, you may lower your hand. You did hear the allegations that were stated on the record, correct?
Yes.
As to the allegations, ma'am, how do you plead?
Mm-hmm.
And you've gone over your advice of rights for probation violation purposes, correct?
Yeah.
And you understand all of those rights?
Yes, he was saying like, pay the, balance over $1,000 and then, continue the probation. Is that correct?
Well, no, first I want you to understand that your various rights that you have for probation violation hearing.
Yes.
And that by entering into a plea that you're going to be waiving some of those rights.
Yes.
And you've gone over those rights with your attorney.
Yes.
Okay. You also understand the possible penalty as a result of your plea, whether in this court, any other court, or administrative agency.
Yes.
And you understand the recommendation in this matter is for probation to be revoked, under advisement status to be revoked, probation violation fee, and it says 15 days jail. Do you understand that?
Yes.
And as well as paying the balance in full. And knowing all that, do you want to continue with your plea?
Yes.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea? Any immigration issues?
No, Your Honor.
All right, counsel, if you can please voir dire your client.
Yes, I'd like to direct your attention to the dates of November 9th, 2022, and the dates of November 29th, 2022. Do you stipulate that you did not appear to probation visits as previously ordered by the court?
You need to speak up, please. Okay.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate, and the court will accept your plea to the probation violation, indicate technical violations 1 and 2 will enter based upon your plea, and counsel as to the recommendation.
Your Honor, my client indicated that she was unaware for whatever reason that this was still an outstanding issue, but she is now gainfully employed. She works at UPS. She's a package handler. She lives in Detroit with her mother. She's not on probation or parole. She's 27 years old. I know it's a little bit older of a case, but I'd ask that she be given an opportunity for a review to see if she can get this balance outstanding and potentially find herself in a more advantageous position. Obviously, with the balance, I think that sending her to jail at this time would potentially lengthen the amount of time that you could get this balance zeroed out. So I'd ask for a delay of any aggressive admonishment at this time, Your Honor.
So ma'am, why didn't you appear over the last 3 years?
At the time, they told me that they had a miscommunication with the case that they put retail fraud when it was attempt retail fraud, and they never made a adjustment on the case. I don't know what that was about, but it was attempt retail fraud, not retail fraud.
No, right. So, but I don't understand how that affects you appearing for your probation
No,
appointment.
I'm saying, like, why would I go to probation if there's like, I'm going to go to probation for something that's not accurate on my.
Because you were ordered to participate in probation.
I'm saying, but it's not accurate.
Okay, so what did you do to try to correct it or bring it to?
Probation officer and asked him to switch it and fix the thing that was on the, the paperwork, and he never fixed it.
And how do you know that was never fixed, ma'am?
I was on the case online. And never said attempt retail fraud, just says retail fraud, it never said attempt retail fraud.
Okay. And so, ma'am, so then you thought it was the best practice to just ignore it?
Not ignore it, like I said, I fought numerous times, never got a call back.
Did you come up here?
No, I didn't come up here, I just gave the call back.
Right, so if it was that important to you, ma'am, why didn't you come up to the court?
This is my first time coming to the court, I never knew I had.
And I'm not sure what you're looking at because I'm showing attempt, I'm showing right on your criminal history, ma'am, it's showing attempt.
Well, that didn't say that in the, online.
So
online said retail fraud, it never said attempt, when they sent me the link, when I just tried to do a background check, it never said attempt retail fraud, it said retail fraud, so.
Well, I'm looking right
That's
at
the
it.
only reason I looked here, because I had did a job and then the background check like popped up for me to do a background check, and it said retail fraud, not attempt
Well, that's interesting because it's also suppressed because of the HIDA status. So I have no idea what it is you're looking at or not looking at. But in any event, you took 3.5 years or 3 years to take care of this.
That's when it's inaccurate, like when they were nothing being stolen or anything, so I'm just trying to see how can we proceed in a proper manner. I know the attorney said, okay, let's fine and then probation.
Well, the recommendation is for probation to be revoked and under advisement to be revoked because you didn't do anything that you were ordered to do, ma'am.
That's what I'm saying, he said just pay the fine and then probation. Correct.
That's not how that works. Just pay the fine and then probation. The recommendation is to revoke probation. You didn't participate in your economic crime program. You didn't participate in your random testing. You didn't participate in workforce. One of the conditions was random testing, ma'am. And you didn't, did you resolve your outstanding warrants?
I'm working on that as well.
Okay.
Go through the list of warrants I have, they have been.
So in July of 22 is when this court sentenced you to those conditions, and you didn't do any of those. Sorry, it was August 15th of 2022.
They like numerous tickets off. You talking about like civil warrants, like driving?
Ma'am, all of the warrants, you had 6 warrants for your arrest.
And I've been paying all of my tickets off. If you go through my civil warrants of driving, I've been paying for numerous warrants off, over $3,000.
Okay.
Over.
And that's good, ma'am. But this court ordered you to participate in probation and you didn't do anything. You didn't appear at probation appointments.
Right.
You didn't do anything. So, counsel, why should this court not revoke the under advisement status and not revoke probation and allow your client to continue when she didn't do anything in the last 3 years?
Your Honor, I'd only ask you to consider that she does have a strong caliber job, and I think that, there was a little ambiguity there. I wish that obviously we could go back in time to get this solidified in a different manner, but she's still in a position where she can clear her balance with the court, I believe, in a relatively efficient manner. And I'm concerned that if it were just to be revoked immediately or put into jail, progress that she's made would be halted. So I'd ask that she be just given a review date on this particular matter to see what sort of progress she makes, because obviously the admonishment of jail or probation being revoked can be implemented at any time. I'd ask that she be given one final opportunity to demonstrate full compliance with this honorable court. Thank you, Judge.
Can I speak?
What's that, ma'am?
I said, can I speak?
What's that?
Like I said, I have been paying over numerous amounts of tickets that like a lot of numerous of my money has gone to. Like I said, my license has been suspended for time, maybe over 5 years. And put like a lot of money towards that. So you can pull it up into the system. It's been Southfield, Lonia. Like I said, I might have ignored this situation, which I could have did, multitasking, did multiple things, but it's only so much I can do with just working at UPS.
I understand as far as the payments, right? You have limited income. However, you didn't do anything with probation with this court. Because you had some information that it was the incorrect plea or charge that was on your record. So instead of coming up and meeting, had you met with your probation officer on those 2 dates, you could have addressed that.
I told you that.
But
it was Zoom. It was
either way, you didn't show up November 9th at 22, you didn't show up November 29th at 22. Here's what I'm going to do, ma'am. You're getting one chance.
Okay.
That is it.
Okay.
The court's going to order your probation to be reinstated or continue probation. Months. Complete all terms previously ordered. $15 days jail. Suspended. Will continue your under advisement status, which will be revoked if any violation.
15 days, you said, so I have to do 15 days?
I suspended it, ma'am. If there's a violation, you'll be doing those 15 days.
Okay.
Okay, stop at probation. Somebody will be with you shortly and we'll go over all of your terms and conditions that were previously ordered. We're going to require you to do all those. Have a good day.
Thank you, Judge.
So I was curious about this because the jail for her was suspended. So I was curious if there's like an overcrowding situation or something like that, because we've seen that before where the judges are encouraged to not put people in jail if they can avoid it. But current Wayne County stats, this is as of today because their their department has a dashboard. Their inmate population is at 1339, which is a lot of people in jail to be sure, but the jail holds about 2,600. So it's not a population problem. They're only at about half capacity. So, but they could have a staffing situation or something like that where they don't have the officers to care for the people. I'm curious if there's something going on there where they're encouraged not to jail people unless they absolutely have to. It's a question. Anywho, let's change it up. Texas, Judge West.
Yes, Your Honor.
You have all his reports, please. Jail reports. All right, are you Aleem St. Clair?
Yeah, ma'am.
And Mr. West, will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Mr. St. Clair, in cause number 23, DCCR 2044, you're charged with the first-degree felony offense of aggravated robbery, and that's from August 15th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? And then in cause number 23, DCCR 2117, you're also charged with the first-degree felony offense of aggravated robbery from August 15th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily, and because you did what they charged you with? In both of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. West?
Oh, this one.
The ones on the tablet?
Oh, yes, ma'am.
And do you understand what you signed, those documents?
When you told me, yes, ma'am.
Okay, and do you understand if I follow the agreement that you made with the district attorney, that you're waiving or giving up any right to appeal? So you can't change your mind if I follow these agreements later and say, I don't want to take these deals. Do you understand?
You say you want to take the deal?
If I follow this agreement and I give you the 10-year deferred probations and all of that, you can't later say, I want to change my mind.
Oh, yes, ma'am.
Okay. And it looks like the agreements that you've reached with the district attorney's office is a 10-year deferred probation in each of those cases. There would be a $1,000 fine in each case. There would be dismissals as part of this in cause numbers 23 DCCR 1390 and 23 DCCR 2043. There would be no contact with the victim. Any additional conditions included after we get a pre-sentence report, which could definitely include some type of treatment, ISF or something like that. Do you understand?
Yes, ma'am.
Do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection?
It's admitted in each case. Is there any evidence that Mr. St. Clair is not competent?
No, Your Honor.
All right.
I'm sorry.
Sure.
If I may, just so Mr. St. Clair understands, typically we don't write that in a plea paper. What my intention was, and what Mr. West and I had discussed based on his very young age, was to be able to include everything that we could to help him at this stage of the game before he gets himself into court trouble. So that was our intention in including that. Those things are meant to help you.
Yes, ma'am.
Thank you, Ms. Malfino.
Thank you.
So states 1 is admitted in each case, and there's no evidence that he's not competent, correct? So, Mr. St. Clair, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your pleas. Find sufficient evidence to find you guilty in each case, but I'm going to reset your cases for sentencing so that the probation department can do that pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing.
PSI bond?
You cannot get a PSI bond. I have 34 pages now of jail incident reports. When you come back for sentencing, if I go along with this agreement, it will require, I'm telling everybody right now, you will go to ISF, okay? And that's meant to give you tools to be more successful. But I don't know, you've been in there long enough. I think you've probably seen 2 that were given ISF, and a condition of their bond, a condition of their probation was not to get any jail incident reports. And they never made it to ISF, and I revoked their probations. And I'm telling you now, I will do that. If you continue to act like an absolute heathen at our jail and treat everybody, including the correctional officers, other inmates, like you have been, you're never going to see the light of day again for a long, long time. These are aggravated robberies. They're first-degree felonies. If you violate your probation, I can give you the rest of your life in prison. Minimum 5 years in prison, up to 99 years or the rest of your life. And I don't know if you can tell, but I hope you can, how serious I am, that this isn't going to be some little 5-year, oh, he was just acting up in the jail kind of thing and he's young. If you can't follow the rules, then you're not going to get these deals and you're going to end up in prison for a very, very long time. So it's time to straighten up. I don't care what everybody else is doing in the jail. You need to go in and say, I don't want this deal. I want to get out. I want a real life. I want a family. I want to work and just have a normal life. I'm going to sit in my bunk when I'm supposed to. I'm going to dress like I'm supposed to. I'm going to do what I'm supposed to, You don't get to make the rules when you're there. You get out, you're on probation, you have some freedom, right? You don't have that freedom in there. Prove to me between now and sentencing that you can do it. Okay, go back with the bailiff.
Thank you. Have a good day.
Thank you, Your Honor. May I be excused?
Yes, sir, thank you.
Plea into each one of these cause numbers. In the cause number 2025 CR 011020, according to your plea bargain agreement, punishment is to be assessed at 5 years in the prison. There's a $2,000 fine. There's no application for community supervision. The state is opposed to your deferred adjudication, and this is to run concurrent. All right, off the record, we appear that we're missing some cause numbers for me. So this is running concurrent with 2024 CR 007176. Was that a motion to revoke or something?
7176.
All right, and has that already been taken care of or no?
He entered a plea of true.
And then we have 2025 CR 011020. That's this case.
Right.
And then 2025 CR 011309A. And okay. All right, I see where we are now.
Okay.
Thank you. All right, so we're back on the record. And then in cause number 2025 CR 011311C, according to your plea bargain agreement in that cause, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication. All cases are running concurrently, and then the state is taking in consideration 2025 CR 011310C and 2025 CC 009777. And in the cause number 2025 CR 011309A, according to your plea bargain agreement, punishment is to be assessed at a cap of 12 years in the prison. There's a $2,000 fine. The state is opposed to your application for deferred adjudication. All cases will run concurrently, and the previously mentioned cases will be taken in consideration. And in both cause number 2025 CR 0113098 and 2025 CR 0113111C, there's an affirmative finding of deadly weapon. And each of the cause numbers, have both parties had a chance to review the PSI report?
Yes, Judge.
Any objections to the PSI report from either party?
The only thing we'd like to point out, Judge, is there was some question about whether he had prior gang activity, and he does not. I think they checked that he did, but they did say it was questionable. And he is telling me he has never been in a gang.
And state, do you have any witnesses?
No, Your Honor.
Defense, the court has reviewed the letter from the defendant, which is the court's understanding that the state had no objections. So I've reviewed that letter. Defense, any witnesses?
We do, Judge.
All right, you may call your first witness.
We would call Mr. Hernandez's mother. Against the counter.
Hello.
Hi, ma'am.
Hi. Could you raise your right hand for me, please?
Yes,
Do you
ma'am.
solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Giovanna McGaha,
All right, I'm sorry.
Giovanna Rebecca McGaha,
Could you spell your last name for the court reporter?
McGaha.
Thank you. You may proceed.
Mrs. McGaha, how are you related to Adrian Isaac Hernandez?
I'm his mom.
Okay, and how old is he?
19.
Okay. And could you tell the court where you live
I live in Smiley, Texas,
and what county is that in,
in Gonzales,
of that town?
in between, I think like 500. I mean, it's a small town, nothing's there.
Okay.
Like 2 schools and a Dollar General.
Okay, and if the court were to grant probation to your son, is that where he would be living?
Yes,
Okay, and there's a school there for him to attend?
yes.
Okay, and could you tell the court why you believe that Adrian should be on probation?
And this ain't an eye opener. I'll be the first thing. I've been praying hard, and with my faith and his faith, I mean, we've been just striving a long road. But I know God is good. And I got my family all in church with prayer and faith. And I got my mom home with me too. So and I feel also changed. So I'm learning new things too. But they're all going. We have actually a lot of our families together still, and peace are missing peace.
So, Mrs. McGaha, the court's going to want to know how it is that Adrian kind of fell off the path and how you're going to get him back on the path.
Well, I have a day and night with me and my husband, and I always take him. That's why I work at night, so I can take appointments for all my kids, so I can deal with that part in the morning if needed. Finances, I know how we're able to finance if we need help with that. There's people that can help us if needed. Finance wise, or I do try to do overtime so that I can achieve those funds to be able to put that there as well. And then the church has been very helpful and helping us with our children, as well as the school that my children are in, with support and helping us with organizations outside of school to get them in right structure with speech, or any things that they're needing for their health issues or mental states as well.
And was your son in special classes?
Yeah,
Okay, is that a 504 designation, do you
that
know?
was one of them. And he did have also behavior from his ADHD and stuff like that.
Okay, and how high did he get in school?
Well, he repeated 9th grade for a good minute. but they end up passing him through to 10th grade, but that was the last of it. But they only found record here when he was trying to go for GED, only for the 7th grade. So we would have to find a way again, which is very possible, to be able to do so.
And you're willing to do whatever it takes to get him back on track educationally?
Yeah, I mean, I have been, and I haven't let go yet. I'm still here.
And if the court sees fit to grant him probation and puts your son in different programs to try and assist him, will you all be able to transport him or
Oh,
do
yeah.
whatever is necessary?
That's what I do for my kids, though.
And how many other children do you have?
I have 3.
And what are their ages?
5, 4, and 16 months.
We'll pass a witness, Judge. Hang on.
I have a couple of questions for you. Okay, so you stated that you live in Gonzales County, Texas, is that correct?
Like the outskirts of it.
Okay, and how long have you lived there?
Going on 6 years.
So what year did you live there?
2020.
2022 or?
The month I don't, but I know the year is 2020.
Oh, 20, okay. And so regarding your son, I mean, he's 19 now, but this is not the first time that he's
Right.
been for court, correct?
Understood.
So he's been involved with the juvenile system since 2017, you'd agree with me, right?
I don't know the year, but I do know that it's been a while.
Okay, and so before you lived in or in the outskirts of Gonzales, Texas, were you living here in San
Oh,
Antonio?
yeah.
And was he living with you during
Yes.
that time? Okay, and so I guess my question to you is, back in 2017 and 2018 and 2019 and 2021, and 2022 and 2023, all of the years that he was involved in the juvenile system,
Right.
he was living with you up until 20, is that correct?
Probably before that. I don't remember when, because I got in a major car accident and I had to get surgery for that, and then everything came back.
Okay. And so he was much younger than
Right,
you, and he was still picking up charges under your supervision, is that
Right.
fair to say?
I wouldn't say I was the best to the fullest like I am now. I'm a lot more mature. I've grown up a lot more since I was as a young mom too. And at the same time, he was a lot immature himself, which he still needs still growing up, maturity wise, on that specific end. So, and then due to the, and then at the
I'm
same.
gonna ask you a question.
Oh, yes, ma'am.
Thank you. And so during the time when he was involved in the juvenile system, he was also ingesting illegal substances. Were you aware of that?
No.
Okay, and he's living with you during this time?
He do some runaways, so I mean, I would have to do those things too,
Okay.
on that end to put reports.
And so I guess my question to you is what's gonna be different now than before when he was involved in the juvenile system and under your supervision, still committing crimes? But if I'm understanding you correctly, you're saying that you're more mature now.
I'm a lot more mature. I have God on my side, that's one.
Okay.
I know I'll succeed with my son. That'll be number one. And then, 2, I have matured. I have a husband that's he stands strong, and I stand right beside him. And as a whole, we succeed with our children. And we have moved our environment from a quiet place, peace. It's a whole different ballpark from living in this city over here to over there.
Okay. And you're aware that your son was on probation for the offense of evading arrest and detention with a vehicle, which is a felony offense, and that occurred in 2024. Are you aware of that?
I don't remember the year.
But you know that he's on felony probation right now. Do you know that?
I'm not too great with the law too much, but I know he's been in trouble most of the time.
Okay. So he's on felony probation, which means that he's gone before this court and entered a plea, and this court put in place different programs for him to abide by.
Yes, ma'am.
Okay, and he has not done that. Are you aware of that?
Yes, ma'am.
Okay, because he went out and committed an aggravated robbery ×2. You're aware, right?
Now I know that it's been 2 aggravated robberies. Yes,
Okay.
ma'am.
Okay, and so my question to you is, do you think that it's fair, or do you think that it's justice for somebody who's already on felony probation that has shown this court that they have no intention of complying with its rules, do you think that it's fair for the court to give us probation for a second?
I mean, that's what the judge, I mean, I can't give that answer, because, I mean, really, because I'm not the judge to say so, but I can say I'm there for my son.
Okay, that's fair. Thank you. We pass the witness.
No further questions, Judge.
Thank you so much for
ma'am.
giving me some insight into your son.
It's fine.
All right, call your next witness.
We would call Mr. McGaha.
All right, friends, I wasn't intending on doing fourth hour content, but we stumbled into this. Assuming it doesn't drag on forever, we'll see it through.
Could you raise your
I'll
right
keep
hand
you
for me,
updated.
please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. Make sure you keep your voice up so I can hear and the court reporter can hear. If you'll state your name for the record.
Stevens, McGaha.
All right, defense, you may proceed.
Mr. McGaha, how are you related to Adrian Isaac Hernandez?
I'm his stepdad, but I've been in his life since he was around 2.
Okay. And just to cut to the chase, Mr. McGaha, you know that we are here because he has picked up some felony offenses and he has a motion to revoke his felony probation, correct?
Yes, ma'am.
Okay. So the question before the court is, what is going to be different this time if the court were to give him probation and put him on deferred adjudication? What can you assure this court that's going to be different this time to keep him out of trouble?
Well, he's coming back home.
Okay.
And I run a very, very strong household, and he has completed probation when he was staying with us too. And when he did do that, he was living with us.
Okay. And so you're talking about some of the priors that he's had.
Yes, ma'am.
Okay. And the court has a whole list of those, and a number of those were dismissed or rejected, correct?
Yes, ma'am.
And did he complete a couple of deferred adjudication probations under your watch?
Yes, ma'am.
Okay. And are you willing to do whatever it takes to keep him on the straight and narrow, should the court grant him one more opportunity to try and behave on one of her probations?
Yes, ma'am.
Okay. Is there anything that you would like to tell the court that you know is going to be different this time to guarantee or for the court that he's going to be able to be successful?
I mean, he has been successful with me because I do see him, because that is my son. So he does listen to me a lot. And like I said before, when he was staying with us and with me, he had a couple of little hiccups, but he was very, very successful when he was at home. So if he does come out, then he'll be coming home. Because I run a very, very tight ship, especially with all of my kids.
What kind of work do you do, Mr. McGaha?
I am a farmhand.
Okay. And would you be able to get Adrian some work?
Yes, ma'am, I would.
And would you be able to make sure that he makes all of his appointments and that he gets back on track educational?
Yes, ma'am. And then on top of that, I'm getting my wife her own vehicle upcoming soon. So she'll be having that, and then I'll be having my truck. So, and then I'll have my work truck too.
Okay. Is there anything else you want to tell the court?
My son, when he is home, he is very, very successful, especially when I am there. I am very, very stern with him. You can even ask him. He listens to me a lot more because I guess I just have that dad figure for him, that father figure. And I really do want my son home. If he comes home, I guarantee he will more 90%, almost 100% that he will be successful.
We'll pass witness.
All right, state.
Okay, so you've been in the defendant's wife since he was 2 years old. It's about your testimony.
Yes, ma'am.
Okay. And so your wife is the individual that testified before you, correct?
Yes, ma'am.
And she testified that you all lived here in San Antonio, Texas until year 2020. Is that accurate?
Yes, ma'am.
Okay. And so then both you and her moved to the outskirts of Gonzales, Texas.
Yes, ma'am. And then we purchased our own property.
Okay. And that's where you're living
Yes, ma'am.
currently, correct? Okay. And so I guess my question is, why was the defendant not living with you at the time that these offenses?
When he wasn't living with us,
Well, why was Why didn't he go with you in 2020?
in a 2020 is it was like a big old thing that just happened and incident that happened at the house. So I had to move my family out, and then my son stayed with his grandma, if I'm not mistaken. And then he did stay with us a couple more times after that. And then when he was staying with us, he was in school. He had everything done, and everything was good. And then my son is he he almost had it completed, and then when he turned 18, I do believe, that's when he fully moved to San Antonio.
Okay. So when he turned 18, then he moved out from you and his mom and returned back to him.
Yes, ma'am.
And so it's your testimony that, you know, he's been successful in the time he was living with the contract. And you described the problems that he's had as hiccups. But you would agree with me that there's some pretty big hiccups, right?
I had some pretty big hiccups too.
Okay, that's not what I'm asking. Do you think that it's a bit, would you describe it just as a hiccup, an aggravated robbery where he knows that his friends have guns and they're stealing property from people?
On
Is
that
that a
end, ma'am,
little
I
hiccup?
do not know. I do not know because I was not there.
Well, I'm asking you.
So,
Do you think,
on-
listen to my question, do you think that him acting along with his co-defendants, if he sees his co-defendant has a gun and they're pointing it at an innocent civilian and taking that civilian's property, do you think that is a big hiccup or a little hiccup?
I couldn't even see my son doing that in the first place.
Listen to the question.
That is the
Is
I'm giving you an
it
answer,
the
ma'am.
facts that I've described to you, is that a big or little hiccup?
On that end, I do not know, ma'am.
Is it a big or little hiccup?
I was not with him.
The facts that I'm describing to you, if somebody pointed a
can't
gun
say
in your
that,
face
ma'am.
and took your property, would
I
that be a
cannot
big or
say
little
that.
hiccup?
I cannot say he did or did not because he was not with me.
Asked him as
So,
a judge
I
and
say-
argumentative.
Or a big
Excuse me. So just listen to the question and answer the question, okay? All right, you can ask your question.
Facts that I've described to you, hypothetically,
hypothetical.
if
Okay.
somebody acted along with another co-defendant and one co-defendant had a firearm and pointed it at an innocent civilian and the other person started taking that civilian's property, would you describe that as a big or little hiccup?
I would call that as a big hiccup, yes, ma'am.
We pass away.
We have nothing further.
All right, sir. Thank you for giving me some insight into your stepson. I appreciate you coming in to testify.
Yes, ma'am.
All right, thank you. Call your next witness.
We have no further witnesses.
All right.
Unless, did you want to say anything to the court or do you want to just rely on your letter?
Just want to say that.
Well, here's the thing. If you want to say something to me, then I'll have to swear you in and the state will get a chance to ask you questions. Sorry? All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Adrian Hernandez.
All right, and before he begins talking, did you want to confer with him a little bit about whether he wants to say something to the court or not?
Yeah, if I could just
Yes.
briefly. Want to do that? Okay. Judge, he'd rather just rely on the letter that he gave the court.
All right. Then let me call this cause number because I see that there were not pleas entered and it's the motion to revoke. All right, the court is calling 2024 CR 007176. Mr. Hernandez, I'm going to show you what's entitled the motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Oh, yes, ma'am.
Are you the same Adrian Isaac Hernandez who was placed on community supervision in 2024 CR 007176 for the offense of evading arrest or detention with a vehicle on August 5th, 2024 for a term of 8 years? Is that you?
Yes, ma'am.
All right, state you may proceed.
Violation of condition number 4 in Bear County, Texas, the defendant Adrian Isaac Hernandez did then and there fail to report to the supervision officer as directed for the month of May of 2025 in violation of conditions.
How do you plead to that? True or not true?
True.
We'll waive it down in there.
Any objections to the waivers?
No objections.
Would you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, and sentence you up to 6 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there a proposed agreement with regard to that motion?
There's revocation and for 6 years in prison.
All right. And defense, the court will, with regard to that, I'm assuming you want him continued.
Correct, Judge. We'd like it to run all concurrent with what his new offenses are.
All right. And then state, since you're opposed, I'll hear your argument, and then defense, I'll hear your argument for the cases that he's here to be sentenced on, as well as the motion to revoke. I think it'll flow smoother with that. All right, state.
Judge, so we are asking that you deny all of his applications and sentence him to 12 years in the prison and the aggravated robbery cases, and then 5 years in the prison on the collision case. Your Honor, I do appreciate in reviewing the PSI that this defendant did somewhat take responsibility for his actions, and he did enter into a plea, and his role was taken to account in the plea bargain. That's why he was given a top 12 of post, because he took responsibility and because he's not the person that had the fire. And the evidence that was stipulated to, he's acting with 2 co-defendants, and they were engaging in burglary of vehicles and local businesses in San Antonio over on the far west side. And basically, they were going and pulling door handles and seeing what they could get into. And an uninvolved, innocent bystander tells him to, hey, knock it off. And his co-defendant points a gun in that person's face and tells him to get the fuck out of here while he is receiving property from the other co-defendant. Your Honor, he was already on felony probation, and this court has given him an opportunity to rehabilitate himself and be a productive member of society. And he has failed to do that. And if the court were to grant his applications, he would fail to do it again. Based on, and then also in the collision case, he's driving recklessly, crashes into somebody, causes them an injury, and then he doesn't turn himself in for any of this. SAP has to go and get him out of his house. So he can take responsibility in that regard, but in the PSI he did, which I appreciate, but we are asking you to deny his applications and send it to 12 years.
All right. Judge, I think that the state has actually hit the nail on the head. He is extremely remorseful, and I think that the court can see that in the PSI, which is kind of unusual. You don't really see that level of remorse or taking responsibility for actions in my experience anyway, in these PSIs. I think this has been a tremendous wake-up call. I think that the family has rallied and is stepping up to take some responsibility to make sure that he can stay on the path. He has definitely gotten off the path. There were definitely people that were hurt as a result of his actions, and he is very sorry for that. I think that he has had a bad time in jail, and I think that this has shown him that he cannot go down this path, that he cannot be with these types of people, that he needs to live in his Smiley, Texas with a population of 500 and get his GED and go to classes and get a trade and go to work and stay on the straight and narrow. And I think he needs his dad, who appears to be a very strong father figure, to be in his life and to keep him on the straight and narrow and make him a productive citizen. And I know the court will have a number of programs and things to assist him with that. And I think that he is receptive to all of that. And so we are asking the court to grant his deferred adjudication and to run it concurrently and to keep him on probation in his evading case. And in the alternative, Judge, then we're asking for the lowest possible sentence that the court could deliver.
All right, Mr. Hernandez, I want you to know that I've heard all of the testimony. I've internalized everything that has been said. I just don't think that you're a good candidate for probation. So in cause number 2024 CR 007176, the court will revoke. The court is finding for true. The court will sentence you to 6 years in the prison, give you credit for any time served. There's to be no contact with Gustavo Perez. This is the run concurrent with 2025 CR 011020, 2025 CR 011311C, 2025 CR 011309A. Our request to the therapeutic community, and there's to be no residing with minors. Did you review the document in that case entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? You do have a limited right to appeal in that cause number based upon the allegations in the motion, not the fact that you were on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And cause number 2025 CR 011309A. Court is going to deny your motion. Court will find you guilty. There's an affirmative finding of deadly weapon. There's a $2,000 fine. Time and money will run concurrently. This is the run concurrent with 2024 CR 007176, 2025 CR 011020, 2025 CR 011309A, 2025 CR 011311C. Taking consideration 2025 CR 0133, I'm sorry, 2025 CR 011310C and 2025 CC 009777. There's an affirmative finding of deadly weapon. Court will sentence you to 12 years in the prison. Give you credit for any time served. Restitution, if any, to Shamari Moore. There's to be no contact with Lincoln Gage Mertens, Oscar Carvajal Jr. Is there anything else with regards to sentencing under that cause number?
No, I don't believe so.
And that cause number, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And cause number 2025 CR 011311C. The court is finding you guilty. The court will sentence you to 12 years in the prison. Give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with 2024 CR 007176, 2025 CR 011020, 2025 CR 011309A, 2025 CR 011311C. Take in consideration 2025 CR 011310C, and 2025 CC 009777. There's to be restitution, if any, to Paul Hike. Court will recommend the therapeutic community. And there's to be no contact with Lincoln Gage Mertens. And that cause number, is there anything else with regards to sentencing?
No, ma'am.
I'm sorry, there's an affirmative finding of deadly weapon.
Just the other thing is that we asked for a no contact order with the other co-defendant, which is Oscar Carvajal.
All right, and no contact with Oscar Carvajal. And no residing in households with minors.
Is there a fine on that one?
No. And that cause number, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because it's a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. And cause number 2025 CR 011020. Court will find you guilty. Court will sentence you to 5 years in the prison. Give you credit for any time served. There's a $2,000 fine that will be probated. This will run concurrent with 2024 CR 007176, 2025 CR 011020, 2025 CR 011309A, 2025 CR 011311C. Take in consideration 2025 CR 011310C, 2025 CC 009777. There's to be no contact with Lincoln Gage Mertens and Oscar Carvajal. There's to be restitution, if any, to Mia Alaman and Sandra Marin. And the court will recommend the therapeutic community, no residing in households with minors. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. Here's the thing. I know it's a lot of time and you're very young. When you go to prison, do not become institutionalized. Go there, keep your head down, try to get your degree. I will tell you, I've had clients before, and the best certification you can get, it may have changed, is welding. Because with welding, they get paid a lot of money. It'll be something that you'll be able to support yourself on, okay? All right, good luck to you.
Good morning. Are you Desarian Adams? And this is cause numbers 23, DCCR 0492 and 0493. Mr. Adams is on probation in each of those cases for the third-degree felony offense of deadly conduct discharging a firearm. Was placed on probation September 26th of 2023. Looks like the allegations in those motions are an alleged new offense of fleeing from a police officer in December of 2025, unlawful carrying a weapon December of 2025, failing to associate with disreputable persons or be present at a location where criminal act was committed, failing to report the arrest, failing to perform community service, out past curfew, possessing a firearm in violation of probation, behind in fees in both cases. Mr. Burbank has filed a motion asking that I set a bond in each of the cases. He's on deferred probation, and at this time, there's no bond. Is that correct? Mr. Burbank, you may, Mr. Adams, best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. Mr. Burbank, you may proceed.
Your Honor, just for, if I may, just make a brief statement.
Sure.
These two new offenses are Mr.
I need everybody to hold it down. I need you to speak up a little, please. Thank you.
These two offenses are misdemeanors. I have talked numerous times to the district attorney. He has cooperated and as much as he can. We do not have the actual police reports except the PC. I don't know if you have the PC or not.
I don't, that's what I was
Judge, I was
looking
gonna tender
for.
the copy of the probable cause affidavit to the court.
You can tender it.
I marked the states as one, Your Honor.
No, any objection to states
Oh,
one?
no, I-
Thank you.
One of the things that we are lacking is the video of the scene because I read it as a defense attorney, kind of have questions in reference to the charge itself. The firearms being in the back seat, there were other people in the car. And the firearms were next to them. No one claimed ownership, but basically because he was the operator of the car, he was arrested. I will also submit to you that he was probably the only one that was not intoxicated at the time, and as such, it was not his car, and he had to get home, and so he was the designated driver at the time. And so with that, Judge, the other thing too I want to point out is I've asked Mr. Adams, I believe that he has no write-ups in the jail since he's been incarcerated in reference to any disciplinary actions. And I would like to call Mr. Adams.
Go ahead.
For the name, for the record, state your name. And what I have told the court in reference to your behavior in jail, have you been acting accordingly?
Yes, sir.
And you have not had any write-ups?
No, sir.
How long have you been incarcerated? How long have you been in jail?
18 days.
18 days? Now, you realize that one of the violations is you haven't been doing your community service fully, correct?
Yes, sir.
Have you addressed that problem since you've been incarcerated?
Yes, sir. I connected with my preacher.
Speak up.
I connected with my preacher. And he's one of them.
Who is your preacher?
Jeremy Williams.
Okay, and he has a church on Washington Boulevard?
Yes, sir.
And he has advised or has told you and your family that he would make sure that you got on the right track and did what you needed to do, correct?
Yes, sir.
In addition, your mom's back here, correct? You may not have known that, but she's here, right?
Yes, sir.
You realize that you shouldn't have been where you were, correct?
Yes, sir.
And you shouldn't have been in a car with firearms, right?
Yes, sir.
Though we do have affidavits from the people there claiming ownership, we haven't gotten to that point yet. They were not your firearms.
No, sir.
Okay. If the court was to consider to post a bond, do you have any problem living with your mom? Or having a monitor on? Or any other type of monitor to whether drugs or alcohol or anything like that, correct?
No, sir.
and abide and try to get back on track again.
Yes, sir.
You do not have any assets in reference to bank accounts or anything like that, correct? And though I am here, this money came from family members, correct?
Yes, sir.
You don't have anything to post, well, you would have enough to post a reasonable bond, if one was, set, correct?
Yes, sir.
I have nothing further, Judge, unless you may have some questions in reference.
Give me just a second. Thank you.
One last, do you have a job?
No, sir.
Can you get a job?
Yes, sir.
When was your last job?
Construction site in August.
In August? So what were you doing on the construction site?
Flagging.
Flagging?
Yes, sir.
You think you can get that job back?
I'm actually getting my CDL. Ms. Joseph hooked me up with the school that I've been getting to, and I'm on my last step of getting my CDL.
So you were enrolled in school at the time that this happened?
Yes, sir.
And you only have one more stage in order to get your CDL license?
Yes, sir.
Mr. Nichols?
Judge, my concern is this, he's on two probations for being involved in a shooting, 2 deadly conducts. It was a situation where shots were exchanged between 2 different groups of people, and he was on one side of that, and obviously there wasn't much cooperation from either side, so he ended up with 2 deadly conduct probations. Here we have him in a car with 2 other guys, 3 people, 3 guns, and the reason, once the officer tries to pull them over, they slow roll for a few more blocks. That's why it's eluding and not, or fleeing a police officer and not evading in a motor vehicle. And of course, during that time, all 3 guns are hidden under a jacket in the backseat. I don't think that's a coincidence. That we haven't delayed pulling over, and then 3 guns are in the backseat. What I don't have is a full case report of all the details, but we can tell that from the probable cause affidavit. I believe the individual he was with is Xavier Kane. Now, if it's not in that probable cause affidavit, then I'm mistaken, because that's the only information I have. If it is Xavier Kane, he's also on felony probation. He shouldn't be hanging out with him. The information.
Who was in the car with you?
Lyndon LaSalle.
Who's also a felon.
Okay.
This is
Lyndon LaSalle?
Junior.
Junior?
I looked this up for Mr. Burbank the other day. There is a Lyndon LaSalle Senior who's a felon. Lyndon LaSalle Jr., I dismissed a unlawful possession of a firearm by a felon case several years ago. That's why I recall his name.
Okay.
He's certainly a person of ill repute.
So he's a prior felon.
He may not be. I think he had a felon. He had a prior felony.
Okay, but not on anything right
That was not the
now.
reason for that dismissal. Nothing current.
I don't believe he has a record, Judge.
Who was the other person that was in the car?
Jordan Collins.
Okay. It didn't matter to me, honestly, at this point, it didn't matter. Okay, what else? Anything else?
Just, if the court's gonna set a bond, it has to be a high enough bond to protect the community. This is his 3rd case involving firearms.
Yeah, so Mr. Adams, the deadly conducts aren't just, I mean, it was a shootout between, I mean, it's just more of the same. Hang on, right now is probably not a good time for you to say anything, like Mr. Burbank. So the first case, or the 2 cases that you're on probation for, 2 people actually got shot. So you and whoever are shooting at each other, you admit it to the police officers that day. So there's no, I didn't do it. You admitted to it, you pled guilty to it, and 2 people got shot, whether it was your bullets or whoever else was shooting. Y'all were all shooting at each other because your grandma's car got shot up. So obviously y'all were getting shot at, y'all were shooting at people, and people who had nothing to do with it ended up getting shot, and you got deferred probation. I sent you to ISF, right? So you've already been to ISF so that you could get right, get the tools to make better decisions. And here you are out at 11:30 at night with 3 guns in the car, smelling like marijuana, cruising around doing what when you're supposed to be at home? with 3 guns in the car.
We actually was leaving the party. I never was in the car. I just
Should
drove.
you have been at the party?
I stayed past my birthday.
Okay. So it's hard for me to believe when you're out at a party and you're on 2 felony probations for 2 people getting shot, that you just ended up in some car. Why didn't you pull over? I'm not asking you to answer right now, but you didn't pull over when they asked you to. When they got behind you, you kept going. So at this time, I'm going to find all right, I'll grant the motions, but I'm setting the bonds in each of the cases at $200,000. A condition of those bonds, if you make them, is that you will be required, and at some point, I thought I put you on house arrest, but I guess you weren't on house arrest at the time of this? Or were you supposed to be on house arrest?
I have paid everything off.
Okay, so you will be, if you make the bonds of $200,000 in each case, then conditions of those bonds are that you have to wear a GPS monitoring device and you will be on house arrest. You cannot leave your house except to come to court or visit with Mr. Burbank without my permission. Do you understand? All right, go back with the bailiff.
We can set this up.
You're watching TCF Live. Happy Tuesday. Good to have you all here. For the new people that are out there, and I know there's a couple of you this morning, I would call your attention to the show that we do Tuesdays and Thursday evenings here. It's called Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. So you get one of those tonight. And this is a community-based show. It was actually thought up by our community members, our channel members. We have some regulars on the panel that are here with you in the chat this morning, and we talk out different topics and whatnot. So be sure to join us for that right here on this channel tonight. I'd also call your attention to In the Blind with Mike and Dan, which is a news show that Michael Groff and I are doing. Since there was some confusion about this yesterday, I want to stress it is not a TCF show. It is a separate thing on a separate channel. Barbara has put a link out there in the chat, so you can check that out. Please do go over there and support us. It's a lot of fun. The thing there is Mike and I have no idea what we're going to talk about until we actually start the show, so it's a lot of fun. Let's go back to Judge West.
-14477 and then 19-32216. Previously in court, pled true to counts, looks like 1 through 6 or 7. The numbers are kind of, pled true to failing to report, failing to appear in court for judicial review, failing to maintain employment, failing to pay, and fail to complete anger management. In each of those cases, I've received an updated report. Has everyone received that report?
We have.
Are there any additions or corrections in that report?
Judge, only addition, if I may, with the court, obviously we understand it's your decision. I have spoken at length with Mr. Burbank about it, spoken at length with Ms. Robinson about it. Obviously, the court will see the age of these cases, especially the one that's from 2000.
Well, they're both only being held, I only have one
Correct.
choice, right?
Right,
Revocation.
right.
I can't extend or
No, and
continue.
that's not what we were asking.
Okay.
We were proposing based on the age of everything, and I believe Mr. Burbank has some testimony to offer with respect to the fact that she was gainfully employed at all times. She admits that she didn't report. I think she's obviously had the problems on probation, but due to the fact that what frustrates me is that she's never been in trouble and she's going to become a convicted felon real quick. She's spent considerable amount of time on these MTRPs over the holidays, et cetera, and we have all discussed asking the court to possibly consider allowing that and maybe a little bit of additional time if you feel necessary to serve as a sanction and just allow her probations to expire out without giving her the convictions due to the fact that these were not aggravated offenses and the age of them is obviously up to you, but that's just something we have proposed.
I also have, for the record, Mr. Burbank's office sent over several letters yesterday, one from Ms. Williams that I've read. And so, Ms. Robinson, you're here today. Thank you for being here. Had some positive things to say as well in the updated precedence report. What are your thoughts on that proposal, Ms. Robinson? You do?
If I could fill in just a little bit.
Sure.
I think she's worked at every restaurant during this period of time. She's worked at McDonald's, she's worked at Cracker Barrel, she's worked everywhere. Whataburger, she has 5 kids, right?
Yeah, 5.
5 kids. She was currently and still, we reached out to Black Bear Diner before she was picked up for this incident. She accepted a kind of a promotion to be a manager there. So she's worked her way up from working there to manager position. And my understanding is that it's probably still available. Her mom is here too, and she would just testify. We have attempted to try to verify the W-2s, but because she's been in here, we've done the best we can in reference that she has been employed, and we provided everything to the state. And I would ask that you consider all that, Your Honor, in the decision.
Well, Ms. Williams, I really appreciate your letter more than some that I get, because it really did seem very sincere. And I appreciate that you have come to realize kind of what started all of this back at what, 16, 15, 16, right? And so that self-realization is big. It's taken a while, but it's big. And so a lot of times I get letters and I can tell someone else probably wrote them, or it was not from the heart. And I appreciate your letter, and I appreciate what everyone's saying here today. And based on all that I will allow the dismissals of the motions to revoke. I'll sign those when it comes through. Do better for you and your kids, so that you're not back in here on anything else, okay? All right, good luck. Yes, ma'am. Yes, sir, thank you.